Ladies and gentlemen, boys and girls, most not though. There's no children that watch this channel, as far as I can tell. But welcome to Friday night. It is Casual Friday in a lot of places, including in my kitchen. I want to hear about what you've had for dinner tonight. I'm seeing nachos, lazy nachos. Oh, damn. So close, not embarrassing myself. But I didn't do it. Anyways, what else do we got? We had somebody has left for spaghetti. Somebody had London broil. No, there isn't Viking. I was going over some of my YouTube analytics the other night. Honestly, the most interesting thing to me is seeing where all y'all are from. It gives me a city list. Oh, shit. We're going to have a ranking system so that you can make your city go higher each week. Talk salad, Mom Hawk. I love it. Audio issues. Okay, well, there's always audio issues for me at the beginning. Let me just get this playing. I'll be quiet and let's learn about what we've got going on here. And then I'll be back soon on camera. This is a long one, guys. Please buckle up. What's up, guys? Welcome back to Kitchen Court Cases, where we watch court in my kitchen. Buckle up because we have a nasty neighbor dispute. We're going down to Texas. I don't even know what else to say.
Slow. Yes. Sorry, you froze on my end. I got you. She's taking down every word. Got you. Okay. So, Jacqueline Gonzalez, our court reporter, is taking down every word we say today. So please be sure to speak at a measured pace. Please do not interrupt others when they're speaking. Let's try to keep our voices pleasant and non-argumentative. I know tempers are high in this case, but that's all right. Court is not the place for that. We're here to try to resolve problems, not to make them bigger. So these are some of the ground rules. I will say that pro se plaintiff and pro se parties do get a little extra leeway from the court, but I at the same time cannot help you practice law. But we will be respectful of your pro se status. Pro se just means without an attorney, okay? All right, so we are here on looks like there was a default judgment entered in this case back on August 23rd of 2021. And it looks like there have been some other motions filed here. We have a December 2nd, 2022 plaintiff's first motion for contempt of court and enforcement of previous injunction for permanent.
We may have feedback. We may have computer lag. I'm going to. Okay, got a little. I'm going to close a couple things, but hopefully that goes a little on their end, like especially at the beginning, but hopefully we get that.
There's also a motion to compel. I didn't really see that was set for today. It looked to me like we were here on the motion for contempt. So with that, and this would be plaintiff's motion, so that's Mr. Wilner. So Mr. Wilner, I'm going to give you an opportunity, even though we're not here on a trial, we're just here on on your motion. I'm going to give you a chance to make a brief opening statement and tell me kind of why you're here today and what we're here about. And then I will allow Mr. Robert Savage an opportunity to respond on behalf of Ms. Chitwood. And then we may actually ask Mr. Justin Chitwood if he has any opening statement to say. So this is a short statement. Mr. Wilner, tell us your views on what's going on today.
Okay, thank you very much, Your Honor. Just with regards to, and I'm just going to mute my own computer here a little bit to stop this feedback. This matter has actually come to court several times now and has been delayed and held over. I believe that the reason why the motion to compel is not properly recorded is some sort of a clerical error, although I could not identify where that might be. It certainly was on the docket for our last appearance in front of the court. At that last appearance, the Kelly Law Group had presented itself as being newly interested in the case. I did want to point out for the record, Your Honor, and I'm not sure if this is appropriate or not, but Kelly Law Group appears to have a conflict of interest, which I would like to just have noted for the record, in that they were originally retained by Ms. Chitwood's son, Brandon. And we have in writing emails from the Kelly Law Group stating that Brandon's sole interest in this matter was his personal acquisition of the property at 106 West Wheeler Street. It would appear...
Is that your property or is that their property?
That is their property. That's Ms. Chitwood's property. And they subsequently sought the custom of Ms. Chitwood and have appeared as counsel of record for her. Her interests presumably are not exclusively that Brandon should acquire this property, given that she is facing possible jail time and $100,000.
Yes. Let's do this. I hear you on the conflict. I hear you on the motion.
Okay.
But I need to hear from you on what's been set for today. And that is really your motion for contempt of court.
Yes, Your Honor. So there was a previous default judgment.
Yes, I saw that.
There were strict injunctions, very specific injunctions against certain types of behavior, including throwing things across the property, yelling, engaging in abusive conduct, etc. And to keep it brief, I won't read all of that. I'm sure it's in front of everyone. Every single one of those injunctions has been broken many times, and we've listed just a few of them in our motion. We have some shocking security camera video footage here. It's extremely compelling. It seems as if the previous injunction did not abate the nuisance. It actually aggravated it to the point where death threats, threats to rape my wife, threats to shoot my dogs and kill me in my front yard, clients leaving the building. We have conversations caught on camera where they're asking if it's safe to stay with us in our business. It's really become a nightmare, just a hellish nightmare here for the last year and a half.
Okay, very good. So what I have here is I have read the default judgment, and I have gone through all the incidents set forth in the motion for contempt of court and for enforcement of previous injunction, for permanent injunctions and foreclosure property. And I read all of the allegations. It sounds like what you're saying.
Let's fix this up, hopefully. While we're waiting, does anybody in the chat can you explain what is going on, or is it not explainable? This guy is a pro se litigant and he is filing a contempt hearing. No, so I'm gonna try and fix it. Is my voice coming a little better? What I'm gonna do is, um, just give me 1 minute of grace so that I can try and do it better. But first of all, the guy's camera is very pissing me off, but it is the whole time. That's just the way he is. Okay, there it is. Oh my god. Okay. We are gonna have to do just a bit of adjusting, and then we'll see. Oh, maybe that will help too. Okay. I also closed the chat that was on my computer because, to see and all. I gotta fix the speed on this one now, though. Damn it. Okay.
It sounds like what you're saying is that even since then you've had some problems. Is that right, Mr. Wilner?
We've had many more problems than we had that prompted the original default judgment, and of much greater severity.
Okay. And what are you seeking today?
We're seeking the enforcement of the injunction. It was very specific: $10,000 fine and or 30 days in jail, for instance, of violation of the previous injunction.
Mm-hmm.
We have listed some that we would like the court to consider, and we're asking the court for enforcement of fines and jail time on those.
Mm-hmm.
The danger to ourselves and to our neighbors in the form of shots being fired, etc., has elevated to the point where it reaches. We've been advised by previous counsel that it is now a nuisance to the public, and for that reason, we're seeking that the property should be shut down as a matter of public safety.
Okay. I saw in your motion you'd contacted the Manor Police about some of these. What has been their response?
We have, Your Honor. I ran for city council in Manor 3 years ago, and prior to that, Manor Police Department were helpful. They did issue citations against Justin for poor behavior, for disrupting the peace, for several fines were issued, etc. However, the moment I ran for city council, all of the Manor Police Department ceased, and they refused to allow us to bring charges against the Chitwood brothers, even though we captured them on video camera shooting one of our guests, who was a nursing mother holding her infant child at the time with a pellet gun. It's just outlandish lack of police support from the Manor Police Department, and it's actually my intention in my closing statement to ask for your help with that matter.
Well, I don't know that that's set for today, but you've given me a good picture. Thank you very much, Mr. Savage. Please tell me your views on what we're doing today.
Good morning. May it please the court, Robert Savage with the Kelly Legal Group for Ms. Curry, previously announced. We are here in response to motions filed by Mr. Wilner with respect to his motion for contempt. Is my audio coming through okay?
Yeah, I can hear you. Mm-hmm.
With respect to his motion for contempt, we have received an email from Mr. Wilner last night around 9:01 p.m., which included around 200 or more exhibits and a number of witnesses. I have been frantically trying to identify what specifically he intends to introduce today. There's been no disclosures he has produced to date, but we are here in response to his allegations. We filed a response, and we have scrutinized the record and information that's been available to us, and have identified no indication that Ms. Curry has received notice of the default judgment that is at issue. The court attempted to serve it through through the clerk's office, and that service came back undeliverable because there was no such street address on the notice. And so my client is here today in response to a default judgment prohibiting conduct that it's not clear she was notified she was prohibited from doing. And I would add conduct that she would have been doing, on her homestead at her personal residence. But we are prepared to proceed, and we would object to as we get into the evidence as needed. But that's the general gist of our position.
All right, thank you very much. We also have Mr. Justin Chitwood here, who is a plaintiff. He's not represented. Mr. Chitwood, do you have anything to say other than what Mr. Savage has already said?
No, Your Honor, I do not.
All right, thank you very much. All right, Mr. Wilner, we are here on your motion. We're checking what Mr. Savage has said on the notice on the default judgment. I think what Mr. Savage is saying, Mr. Wilner, is that we're looking at it to the degree that we can, is that Ms. Tracy Curry did not get notice of that default judgment. Is that, tell us your views on the history of that.
Okay, most of the service, and I don't mean to sound, obstreperous here, but almost all of our service prior to the Kelly Law Group's involvement here was accomplished via Rule 106. And this is because the defendants were extremely aggressive and trespassed all efforts at service from the property. And I believe that Ms. Johnson and her process server are going to testify as to the rude reception and potentially violent reception which they received. That being said, I do take exception to the comment from opposing counsel about there being no disclosures. Kelly Law Group has been counsel of record on this matter since January when this first came to the court. We uploaded substantively the exact same exhibits that we're prepared to offer today, although we have pre-warned them that we would be adding some additional exhibits today, although I would say less than 10% of them are new. So that's factually incorrect. I did notice that opposing counsel became counsel at the last minute. It is counsel of record from Kelly Law Group until very recently was a Christy Applegate. And we did wonder why she was substituted out. We checked their website last night. We find that she's no longer listed on their website.
There's a lot of movement among attorneys. I will say that I've certainly noticed that same trend, Mr. Wilner.
Yeah.
I didn't really get from Mr. Savage that he's saying don't go forward today. I did hear him complain about it, but I didn't hear him say they're not willing to go forward. So
yes, Your Honor.
unless I'm missing something.
Yeah, I just wanted to take exception to his assertion that there have been no disclosures. They've been in possession of hundreds of our exhibits for more than 2 months.
So, okay. So with that, Mr. Wilner, we are looking right now at the notice on the default judgment. So we're going to have to take a minute to look for that. Did you have something else you wanted to say?
Yes, I did. I also, and again, I'm not a lawyer, but I believe that any errors in service which might have been attributable to us previously would have been cured in the previous appearance in front of the court and by providing all of those documents to opposing counsel, because they were served with all of those documents subsequently and had access to them through I believe it's the Odyssey portal, is it? And we also were engaged in settlement discussions with Kelly Law Group prior to this appearance as well. So they cannot claim that these were not properly served.
Okay. Mr. Savage, when did you get a copy of the default judgment?
Me personally, I am new to the case, as Mr. Wilner has.
When did the law firm?
I think our office received it shortly after we became retained and enrolled, which was not until January. And I point that out because I think almost all of the conduct that could be mistaken occurred before that. That is at issue today. So certainly, I would add, if it may assist the court, that notice I was referring to with regard to the default, I think that came back to the court as return mail on or about September 22nd, 2021.
And that was the original notice of the default was returned, you said?
Yes, ma'am.
In September. And you're saying that your law, so since you represent Ms. Curry, obviously, your law firm is going to, be, if you have notice, she has notice.
Right.
Yeah.
Right.
Not you personally, your law firm. When did your law firm get a copy of that default judgment?
I can find the specific date.
Yeah, we need to know that. That would be helpful for us. Let's take a minute.
Your Honor, also, if I may, previous counsel was a gentleman named Len Green, and he should have copies of all of this, including the service. I also have video, as luck would have it, the constable, oh, that's not it. This is my sweetheart is here also advising me with keeping the facts straight, but we should have proof of all of this, Your Honor.
Okay. What we're trying to determine, Mr. Wilner, is when Ms. Curry or her attorney received a copy of that default judgment. That's kind of critical here. That's why I've asked Mr. Savage. He's an officer of the court, and he is bound to be truthful with me, or he's going to be in a lot of trouble, and he knows that. We all the lawyers know that. When the law firm first got notice of that will be attributed to Ms. Curry. On your end, if you have any indication, any documents that show she got it prior to whenever he's going to find it, he's looking right now. That would be helpful to know.
We will also review our records during that time as well.
Okay, just go on and take a minute, both of you all, to do that, because I want to make sure of when she got notice on it.
If I recall, we had that little 106. It would have been posted on their
We have photos of that.
door.
We have photos of it being taped to their front door. Let's see if we can find those photos, Laura.
Judge, are we off the record? Otherwise, I need to take Mr. Wilner and his wife down. Let's go off the record just for a minute, Ms. Gonzalez. Thank you for that, and let's let them look for just a minute, okay?
Thank you.
And in fact, if you all need to be placed in a breakout room so that you can talk a little more freely with your wife, Mr. Wilner, or Mr. Savage with your assistant, we can do that as well. Would you like that?
Your Honor, I'm fine proceeding with, my witnesses now they're all business owners, and they've all taken days off of their companies.
Yeah, no, I understand.
So I want to suggest that perhaps we might continue with the hearing, and we can come back to the court and bring whatever evidence we're able to find. We may need to track down previous counsel and, for lack of a better word, badger him to forward us confirmation of the work that we paid him for, which he supposedly completed.
I understand 100%. Mr. Savage has raised a good point, which is and I'm not, believe me, I understand. We're dealing with a neighbor dispute. They can sometimes be very, very difficult to resolve. I'm just trying to see when Ms. Curry got notice of this default judgment. It is. I think that's a pretty critical point. So we're looking. Just give us 1 second here, because the concern is this. I don't. If you're asking me to hold them in contempt for violations before service of that default judgment, that I don't think under law I can necessarily do that. So that's what I'm asking Mr. Savage about. Now, he seems like he's looking here carefully.
Unless our and please take all the time necessary. We, out of respect again for our witnesses, we'd like to take whatever time is necessary to dot all the I's and cross all the T's, Your Honor, and make sure that we don't have any need to call them back at a future date.
All right, Mr. Wilner, let's go in and put you on mute for just a minute here, and you talk to your wife about it. because we don't, I need Mr. Savage to go figure out what's going on, with this. And he knows that if he's not honest with me about it, it's going to be a problem. So he's trying to be very carefully. Let's go on and go and recess for just a couple of minutes while Mr. Savage finds out this notice issues. That gives me a chance to look at our court database as well. All right, for the next, let's see, it's 9:58 until, or 9:48. Let's be adjourned for 10 minutes. We'll come back, actually 12 minutes. We'll come back at 9:50.
Thank you, Your Honor.
Back on the record. I'm going to give my staff attorney just a minute to get back to his office. Here's what it looks like to me. It looks from the clerk's record, which we'll show you in just a minute here. From the clerk's record, it looks as if, at least from what we have, that Miss Tracy Curry did not get at least official notice until January of 2022. And so we're going to show that to you. Can you all see that? We're just showing it to you right now. You see where it says return to sender? And that was from September the 22nd of 2021. So we also see, though, in the court's file that a notice was sent to Mr. Chitwood. We do not have a return on that. So he did receive notice, according to the court's file, in September of 2021. So I think that in my view, it makes sense to go forward on Mr. Chitwood today, and honestly, most of the allegations seem to relate to him. Ms. Chitwood is on notice, however. Her attorney is here, and B, we did see that she received the contents of the temporary injunction. I'm sorry, of the court order, the default judgment, on the motion for okay, hang on 1 second here. We're still trying to figure out y'all's timeline.
Your Honor, if I
Yeah, no, not quite yet. Judge is still talking. Okay. It looks like Ms. Tracy Curry Chitwood received hers on the motion for contempt by substituted service on December the 19th of 2022. So that was quite a bit further along. Nonetheless, Mr. Chitwood does have notice, and he has had notice for quite a long time, since September of 2021. So with that, Mr. Wilner, we are going to go on and ask you to put on your case. Mr. Chitwood will be responding now. Anything that happened after December the 19th of 2022, which is when Ms. Chitwood, Tracy Curry Chitwood, got notice, she is going to be tasked with responding to that information. These are very serious allegations today. They could result in fines, potentially jail time. There's an allegation of wanting to lock up the property. So these are to be taken seriously and to be taken calmly today. So with that, Mr. William Wilner, proceeding pro se, I want you to go ahead and starting with the things that have happened after the motion, the default judgment was sent to Mr. Chitwood in September of 2021. Things that have happened since then that show that there's contempt of court in that previous judgment that was signed. And you may proceed.
Thank you, Your Honor. I will note that we were able to discover compelling evidence of service on both the defendants during that 10-minute break. We have forwarded photographic evidence of service to Monteguardia. It will have just arrived to her a couple of minutes ago. We also contacted previous counsel. That was the incoming phone call that we all just heard a moment ago. Previous counsel is also prepared to testify to the effect of service having been completed against both of the defendants. So I don't know what the import of that is, what the appropriate thing to do, but I wanted to let the court know that we have found valuable information with regards to service, so that the court is aware of that.
All right, so let me ask my staff a little bit offline here to please review the information that was sent by Mr. Wilner. We do need to get going today. And it's honestly, at this point, most of them are going to relate. I mean, these are people inhabiting the house, right? So we just received it a second ago. Ms. Guardiola, please review that information with Mr. Dillon pertaining to whether Ms. Tracy Curry Chitwood, when she had notice of the default judgment, that's the key issue that we're on today.
Yes.
Right now, we're going to go on and proceed pertaining to Mr.
Your Honor.
And also, you need to forward that information to. We can't look at it, Mr. Wilner, until you forward that information to Mr. Savage. It's just come to our attention that you haven't. So let's all take a breath here. Mr. Wilner, please send that information to Mr. Savage right now.
My apologies, Mr. Savage. This is not my daily occupation. I apologize.
You're doing fine. Mr. Wilner, you're doing just fine.
Forward. And sorry, sir, can you just remind me of the first few letters of your email?
Your Honor, my email address is rsavage@kellylegalgroup.com.
Okay.
Please see attached.
Thank you, Mr. Savage.
What we have here is, I should note for the record that both the defendants cohabitate in the same residence, and we have photographic evidence of service of the documents posted on their door and on the windscreen of their vehicle. We also, as I mentioned before, have our previous counsel available now to communicate with the court and to explain service that was completed. So that's been sent to Mr. Savage.
Let's give him just a minute to look at it, because he's trying to listen to you. I'm trying to listen to you, and he's trying to read a document. So let's give him a minute here. He has to defend his client's interest here. Mr. Savage, have you received those documents?
I've just received it. Yes, ma'am.
All right. Let's take a minute to look at that. I had said let's proceed, but with those documents, let's take a minute to look at them. I will ask Ms. Guardiola, could you send it to our team chat and I'll take a look at it too? Yeah, Tiffany.
If I may, Your Honor, previous counsel just finished a phone call with my sweetheart and said that he is forwarding the statement from the process server. That should be in our email any moment, and we will, of course, immediately forward it to everyone else as well.
Okay. All right, so we have the JPEGs that we have received from you. They're not. I know, Mr. Wilner, they mean a lot to you. To us, they're just pictures of papers taped to doors and cars, but they're not dated and they're not clear to us what they are. So those, I know this sounds picky, but that's, as you can imagine, over all the years of common law, we are very particular about people getting notice. It's a due process issue if she didn't get notice. So we are looking at that now.
Please, if I may, please have your court staff view the creation dates of those pictures. You will find that they are one day from the date of the returned mail, specifically September 21 and 22 of 2021. I know that that doesn't show you what's actually written on them, but it's proof of when those pictures were taken, and they were taken in response out of an abundance of caution on my part after counsel informed us that these documents had been posted on the doors.
Mr. Savage, have you had an opportunity to look at these documents yet?
The exhibits just transmitted. This is the first I've seen them, but I did review them just now.
I have not personally seen them just yet. We're having some trouble getting the transfer through. What are they? Are they
That's fine.
indicating to you?
They purport to be photographs of a doorway with two pieces of paper taped on them. There's no date that I have found yet. I'm not sure how they're authenticated, and I'm not certain. It does show, I will say, they show that it's 106, and the address of the house is 106. So, giving Mr. Wilmer the benefit of the doubt, it may be the correct house, but the street name is not noted. But the absence of date information or other authenticating information, I think, is something we'd like to address if this were to be considered.
Yeah. All right. I think we still have issues with service as to Mr. Savage's client. I'm not seeing what I need to see to show that she was served. Yes, Mr. Wilner?
We've just forwarded the court and also Mr. Savage the report that I mentioned a few moments ago with regards to service from the process server.
Okay.
And with no disrespect whatsoever to Mr. Savage, and I genuinely mean this, I'm not trying to be cute, you can see the creation date of those photographs simply by mousing over, putting the cursor over a photograph, and or by right-clicking on it if you're a PC user, or just clicking on it once if you're a Mac user, and it will show you the dates that the photos were taken. It'll say created on, and it will give you a date. So that's a timestamp that's embedded directly into the photographs, and that's precisely the information that gets used to authenticate the creation of the photos.
The problem is we can't tell. They look like two pieces of paper taped to the door.
Yeah.
I mean, so that's the issue. So let me look and see what you just sent me here, which is a return. All right, so let's see. Hang on just a second. Just let me read from it. Let's see. posting my door. Yeah, okay, so here's something. Now, this is something a little different here. This is a return. It's a letter from Green and Green attorneys and counselors at law for a note regarding notice of injunction with copy of district court's default judgment and injunction bond and receipt for payment of bond, executed on 9/20/21 at 6:57 p.m. to 106 Wheeler, by delivering to Tracy Chitwood by posting on the door and by placing on the windshield. I think this is notice.
I have not seen this before, but obviously, if it is authenticated as it should be, then we would on the reading of it, it does appear to indicate that. I would like to challenge it to confirm that it is indeed what it purports to be. It is not under seal. There is no witness yet that has been produced to support this, but otherwise, I do see it.
Well, we can spend time doing that, and if you want to do that, we can. But we're going to go ahead now, and we're going to say that your client has had notice. All right. So what we have here is a document that shows Ms. And I'm honestly slightly upset because we've been messing around a long time with this. And if you had that right there, your client knew about it. This is the type of thing that wastes time. So where are we with this, Mr. Sack?
Your Honor, I just wanted to clarify. I'm reading this for the first time.
Okay.
And I recall that there was a verification, so I'm not going to raise that authenticity point that I was just raising. I apologize. I'm reading these in real time.
Okay.
But no, I have not seen this. But certainly, I was going off the public record and the information that we saw, and our position is, if Mr. Wilner is going to levy some very serious allegations, our client wants to make sure that he lays the proper foundation to support it.
All right. Well, she has had notice, and we've been arguing about notice, and it would have been a whole lot easier for her just to say to you outright, "I had notice." So here we go. All right, Mr. Wilner, please proceed.
Okay, thank you, Your Honor. In the interests of not having additional financial hardship myself, I would like to begin. I'm going to go through this a little bit out of order, and I apologize if it gets confusing, but I want to send my witnesses on their way. So I'd like to have Corinne Johnson sworn in to respond to the claims by opposing counsel alleging flawed service. Any issues of flawed or failed or incomplete service should obviously be addressed now since it's come up.
And who is she?
Corinne Johnson she's on the witness list. She is the owner operator of SPAR Service. I'm sorry, Corinne, I don't want to get the name of your company incorrect.
SPAR Process Serving.
Gotcha.
Yes,
all right, very
she's
good.
the one who is-
Ms. Johnson, would you please raise your right hand? Okay. Do you solemnly swear or affirm under penalty of perjury that the testimony that you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right. Mr. Warner, you may proceed to question this witness.
Okay, thank you very much, Your Honor. Corinne, I want to try and keep this as short and sweet as possible. I forwarded you a copy of the allegations of improper service and our most recent service to the defendants that were sent by opposing counsel. I would like for you to just read those to the court if you would, and then just respond to those in your own words if possible.
Sure. So when you sent me these opposing counsel's response, you specifically pointed out 7 and 13, saying that number 7 says the charges were not properly served pursuant Rule 21A of the Texas Rules of Civil Procedure. Wilner's motion for contempt contained no required certificate of service. Moving on to 13, it says Ms. Chitwood was not properly served pursuant Rule 21A of the Texas Rules of Civil Procedure. Wilner's motion to compel contained no required certificate of service nor a certificate of conference evidencing efforts to resolve the matter without necessity of court intervention. And so it just would be, if I'm reading that correctly and understanding it correctly, it would be an accusation that we as our process serving didn't complete the service as we stated in our affidavits of service that were filed with the court. And I just have a personal issue with that because that's not true or accurate.
Okay, and that's why I wanted to invite you as much as request your presence today, just because I understand that your reputation and the reputation of your company to continue doing business, it's critically important that you don't allow allegations like these to pass by unchallenged. You've got an employee of yours or an associate of yours with you in attendance today as well. I'd like to point out to the court that service was completed under Rule 106. I would like this additional employee to be sworn in so that he can attest to his experience trying to complete service and explain why Rule 106 service was actually necessary in this case.
That would be very helpful. Thank you. Who is the next witness, Mr. Warner?
Your Honor, may I be permitted to cross-examine?
Yes, go ahead, please.
Thank you. I'm sorry, I missed your name. I apologize. I think got the list last night.
It's Corinne Johnson.
Okay, thank you, Ms. Johnson.
Mhm.
I think you were reading from the response on around paragraph 13. Is that correct?
Yes, sir.
Okay, and that was Ms. Curry's response to the motion to compel. Is that right?
Let me scroll up here. Yes, along with other documents, but yes, the response to motion for contempt of court for enforcement of previous injunction, the list goes on and on.
Okay. At the top, do you see that we identify the motion to compel as a discovery motion to compel? It's not the motion for contempt that's being heard today. Is that correct?
Where would I see that? You said at the top.
The first paragraph of the response.
Okay.
We have an abbreviation that identifies the motion to compel and the motion for contempt as two different motions.
Okay, I do see that, yes.
Is in your testimony you were serving the motion to compel discovery in addition to the motion for contempt?
It's my testimony that the document served on December 2nd. I'm sorry, let me change my date there. On December 16th at 10:19 a.m. by Rule 106 was plaintiff's first motion for contempt of court, for enforcement of previous injunction, for permanent injunctions, and for closure of property, order on motion for substitute service of process on Tracy and or Justin Chitwood.
Okay. And what you were serving you were serving the motion to compel. You were not serving the discovery request for that first time, were you? Was that the first attempt to serve the discovery request on Ms. Curry? You're aware of?
I do not see where we attempted to serve a discovery request.
Okay, thank you.
Can I redirect, please, Your Honor?
Yes.
Regardless of whether or not that is true, and I'm fully ready to, if we made an error or an omission unintentionally, I believe that any deficiencies in service were automatically corrected as soon as both of those documents were provided to opposing counsel in the last week of January. So they've had in hand for 2 months, and so I don't see that this is relevant. I think it's another effort to delay and avoidance. So with that, I would like to thank you very much, Corinne. Can we please have your employee sworn in now to describe his efforts to try and interact with the Chitwoods?
Yes, Mr. Savage.
Just with respect to the argument that was just laid out, I just need a brief moment to say that we've responded to the discovery and lodged our objections as well. And provided that to counsel, or excuse me, to Mr. Wilner. And so I would be remiss not to point that out so the court is aware that discovery has been responded to.
Okay. I guess I'm struggling a little bit to see the relevance here, Mr. Wilner. What we've produced, and you did a real good job of it, and it's Mr. Savage and his client. I'm not happy. You showed a document that showed that there was discovery that those pictures that were taped to the door, that those were actually appeared to be an attempt to serve default judgment.
Yes, ma'am.
on these folks back in September 2021. So all of the stuff that you put in your motion, you can talk about that today.
Yes,
But
Your Honor.
so what I thought Ms. Johnson was coming on for, and her employee, was to show that way back in September, they were the ones that tried to deliver that service of process. Is that what they're doing? Or
No, Your Honor. There were allegations of improper service in the process of serving this motion and the contempt motion and the motion to compel, and I did not want those allegations to derail these proceedings. And if we've cleared the bar again, this is not my normal job, so I'm
No, I
happy.
know. You're doing fine. You're doing
And
fine.
and we can certainly let her go. I also frankly felt that she was an extraordinary partner to work with in the attempt to try and serve the Chitwoods, who've been extremely difficult, and I felt that she deserved the opportunity to defend her reputation. So if we're finished, I'm happy to move on.
Okay. Mr. Savage, is there any question about this? Don't you have copies of these motions at this point?
The motion to compel and motion to respond, the motion for contempt, yes, ma'am, we've responded to those, and I didn't think that service of those was an issue today.
All right, let's go on and move on to Mr. Walner, okay?
All right, thank you very much for your time, sir, and please thank your employee as well. Even though he did not testify today, I really appreciate him taking the time.
Ms. Johnson, thank you for being here. You may have a wonderful day. We appreciate your patience in this process very much, and we appreciate your professionalism out there in Manor. Have a wonderful day. You may be
Yes, ma'am. Thank you, Your Honor.
Okay, so that takes care of that. Okay, one of the statements, Your Honor, that was also made by opposing counsel regarding their claim that that the defendants are especially exempt to the plaintiff's motion for contempt and the plaintiff's writ of execution required a verified pleading. It's my contention in response to that allegation that we either met it when we wrote the original pleading, which states the grounds for such relief, or that we met it because according to Crystal Media Inc. versus HCI Acquisition Corp. And more than a dozen other examples which we could quote, the verification requirement can be waived when a full evidentiary hearing on evidence has been held, and that's already happened in this case. And we're also doing that now.
Mr. Savage, how do you respond?
We haven't noticed up the special exceptions for today. We just used that in our original response, but briefly, this is a contempt hearing. He's seeking to impose injunctive or enforce a default judgment that was put into effect, and in that proceeding, we would contend that he should verify the assertions that he made that justify the relief he's seeking, and he hasn't done so. But again, I have not noticed that for today. We just laid that out in our response.
Yeah,
Okay.
that's what I understood, Mr. Wilner, too. I saw those special exceptions, and I thought they were a little peculiar, but he hasn't noticed those for today. So let's just move right on to the motion for contempt. Okay, so what we're saying is that there was a motion, a judgment that was entered by the court in August of 2021.
Yes.
And it looks like everybody got notice of that in September of 2021. Both defendants. Now, you know, if Mr. Savage has something else to say about that, then he needs to say it. But it looks to me like both of them got notice of it. So then what you're saying is, yeah, that's right. But what's happened, see, is since they got that notice in September of 2021, other things have happened that actually violate that court order. And so for that, you're asking the court to take action.
Yes, for that.
The action you're asking me to take is to basically lock up the property, put them in jail, and or fine of $10,000 per occurrence. That's what it looks like you're asking me for. So now some of that, you know, let's be real clear. Some of that may in fact be valid, but right now we need to hear from you, or it may not be valid. This is a very difficult time we're in right now. We're trying to hear from both sides. So Mr. Wilner, tell me, let's, you know, we'll swear you in if we have to, what evidence you need to have to show that there's been a violation of that order that was signed all the way back in August of 2021. That's where we are today. Okay?
Okay, Your Honor, I would like to start. I had planned originally to go through all of this chronologically, just for the ease of everyone.
Chronologically is bad. It's not bad. I like chronologically. It helps. Okay?
Okay.
I will do that at the expense of probably $600 or $700 in additional time to my witnesses. Some of the two remaining witnesses, or two of the three remaining witnesses, are also business owners. They are also
Gotcha.
taking time away from their companies. If it's not too onerous for Your Honor, I'd like to deal with those instances first.
You may. That makes sense. Go ahead.
One of them is with regards to the ongoing state of disrepair and the danger of snake infestation that the 106 property represents. This is an addendum that I had wanted to ask Your Honor for, or is it not relevant here?
No,
To not
snakes.
present that?
No
Okay.
snakes. I looked all through it. I saw fireworks, I saw guns, I saw shouting, I saw drug deals. I didn't see snakes. So
Okay.
snakes is not before us today.
Okay. We might bring that back to you. We do have those exhibits and also in our exhibit list about this. Okay.
Renotice
Thank
it.
you, Your Honor. If I may, Your Honor, just real quickly dismiss that witness, Brent
Yes.
Ormond. If you would be so kind as to stay close to your phone today, I understand that you're on a movie set, and we would like to impose upon your patience and goodwill later on if the judge does want to hear with you with regards to the rattlesnake infestation. That was an error of omission on my part by not including that in the pleading, and I accept the responsibility for that. But it is a concern not just to ourselves, but also to the neighborhood.
Absolutely.
Sure, no problem.
Mr. Orman, it is an honor and a privilege to have you here today. I thank you very, very much for taking your time. Unfortunately, this issue is not correctly before the court. It didn't appear to be, but it may be in the future. So, if you would, you may be excused. As Mr. Wilner said, please stay, with your phone where you can hear it. But at this point, you are free to go on about your day. And again, it's an honor and privilege to have you here, but you may be excused. Okay?
Thank you.
Thank
Thank
you, sir.
Brent.
All right.
Your Honor, I would like to call Chris Tate as a witness.
All right. Mr. Tate?
Yes, Your Honor.
All right, very good. So, Mr. Tate, I'm going to ask you to raise your hand, the right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Wilner, you may proceed.
Thank you, Chris. Very much appreciate you taking the time to be with us today, especially during all of the people who are demanding your attention. You've already been sworn in. The incidents that you're going to give witness to today are really quite extraordinary and quite shocking. I'm just very thankful that you happened to be on the property when they took place because you are uniquely qualified to testify to those. For the record, I would like you to describe your expertise, the work that you do, etc. Can you please proceed?
I'm a disabled veteran. I served in the Army, been deployed to war. I own a dog training and dog behavior company. I work with apprehension dogs, protection, tracking, scent detection, and other things as well. So it's kind of my background.
Okay, and just to clarify, because you have an admirable trait, which is sometimes frustrating in that you refuse to talk about the extent of your accomplishments. When did you actually sign up for the Army, and what was your last position before you left? How old were you when you signed up?
I was 17 when I signed up, graduated early, joined the Army, deployed, and I'm a 90% service disabled now.
Okay, and so there are a lot of people and you did 2 tours, if I understand correctly, in my notes here.
2005 and 2007.
Okay, and in what capacity were you deployed on your last deployment?
As a line medic.
And the line medic was with which specific part of the service?
With the Army.
With the Army?
We were attached to different units. The last unit I saw combat with and got a combat badge with was the 101st Airborne.
Okay, so, and with all the things that I have to everybody who does serve the country in any capacity whatsoever, the reason why I specifically wanted to point out that qualification is because unlike a lot of folks who do suffer when they are over seized and deployed and may suffer stress from rockets, etc., exploding nearby. You were actually pretty much continuously on parole in combat for the better part of 4 years. Is that true?
For between 2005 and 2007, we were on continuous combat patrols, Humvees and tanks, air raids, a lot of different combat situations. I'm
Okay.
also an expert marksman. In the Army, I was rated as an expert marksman for pistols, rifles, machine guns, and grenades.
Okay. And upon your return, you got into dog training after your, presumably after your exposure and working with war dogs. You mentioned that you're now a dog trainer. Can I ask you to actually describe some of your qualities? You said you became a dog trainer, and again, very underplayed yourself. So congratulations on your modesty. But can you describe the work that you did with Garmin International, for example?
Well, I used my VA benefits to go to the #1 dog training school in the world. I graduated. I started my own company. I moved to Olathe, Kansas, where I worked for Garmin International, for their corporate headquarters, integrating GPS tracking systems with dog training equipment, helping with that type of implementation. And then I moved back to Texas after my mother got ovarian cancer.
Okay, and then now you continue to provide training, for example, to aid scouting and other law enforcement systems. Do you maintain your?
Wait. Here's the situation.
Yes, ma'am.
Mr. Willer, you're doing a very good job. There's two things I just want to caution you about. I am personally extremely impressed listening to Mr. Tate's accomplishments in his service to the country. I'm extremely moved by this. I have deep respect for our veterans. I just want you to know two things. Don't you testify, you have to ask him questions. So when you're testifying, you need to ask him questions, not comment on the evidence he's giving. Secondly, I need you to, this testimony that you're getting from him, to relate back to what we're here on today. Okay, and it may very well relate back to what we're here on today. I don't know yet, but it needs to do those two things. So let him talk. His record speaks for itself, and it needs to relate to what we're here on today. Okay, and you're doing a good job. I'm not being ugly. I just want you to know, Mr. Tate, Mr. Wilner is representing himself, and he's a few minor bumps in the road. We're just trying to keep it on track because we do have limited time. Mr. Wilner, with those two minor suggestions, please proceed.
Okay, thank you, Your Honor. The reason why I wanted to specifically point out Mr. Tate's expertise with weapons is because he's about to testify on an event.
That's what I thought. Okay,
yes,
please proceed.
And so, Mr. Tate, and also the court in general, please refer to exhibits plaintiff. Plaintiff's
yes,
exhibits.
Mr. Savage.
I just want to confirm that I think this individual may have been referenced as an expert at some point. I just want to confirm if so, if he's proffering him as an expert or if it's a fact witness. I just want to make sure that I'm understanding correctly.
Is this individual a fact witness or an expert witness?
I apologize. I don't know the distinction between those two. I was going to ask the court. I had this speech, put together where I was going to ask Your Honor, do you accept his qualifications as an expert with regards to identifying an AR-15, for example?
He's got it somewhere in between. If he's just trying to identify an AR-15, but that's as opposed to a child's toy or something else. I think he has put forth enough information to do that, Mr. Savage, with his military training, expert marksman. I think he said enough for that. That's just my view. Mr. Savage, please respond.
Well, what is the scope of expertise being offered? Whether he is someone who can identify a certain type of weapon. I'm trying to understand what is the scope of the expertise. I understand he has a very solid history with the military, but I want to make sure we have a good understanding of what expert opinion here will be offered.
All right, so Mr. Wilner, what expert opinion are you expecting for him to offer?
I would like to, if I can actually provide these video clips to the court, We will see.
Just tell me.
Yeah.
Just tell me. What's he doing? What's this man here for?
He's here to. We were confronted by an individual on Miss Chitwood's property, brandishing an AR-15, threatening to kill people. A convicted felon who happens to be another one of her sons, Mr. Tate, and this other individual, Billy Chitwood, who has numerous felonies convictions in 3 different counties, were within feet of each other when he brandished an AR-15, talking about killing me. And this is the same.
What is AR-15?
When he brandished an AR-15, racked the charging bolt, and made threats. I would like all of this was captured on video. I would like to play that video for the court. Mr. Tate appears in these videos, and I want to ask him to identify that. So, Mr. Savage, I can certainly appreciate your question.
You have to address me, not him.
I'm so sorry.
That is a rule of court.
I'm so sorry, Your Honor.
No, you've done it. You've told me your views. Now let's hear from Mr. Savage. Mr. Savage, how do you respond?
If this is a fact witness, I have no issues and would just ask the opportunity to cross-examine it so we can test the evidence. If the question is one of, if there's evidence of a firearm, I'm not sure how much of an issue we need to go into what type of firearm, but certainly I don't have an issue of him using his experience to talk to the issue that he's here to testify to. I don't want to be unreasonable.
Well, I think this is relevant, and I do think that he is a witness who can testify as to it. I will say that when you read the straight allegations up, it is a concern of mine. Is this an actual firearm or is this a child's toy? What is this? And I think that Mr. Tate has certainly, based on his experience in the military and his recognition as an expert marksman, is able to testify to that. Where someone, your average human being might not have that experience. I think his lifetime experience has provided him with that. So, with that, Mr. Wilner, you may proceed.
I'd like to.
To the degree there's an objection, it's overruled. Go ahead.
If there is I'd like to direct the court's attention to Plaintiff Exhibit 151, which will be followed by 152. Oh, no, sorry, my mistake. No, that's correct. I apologize. Thank you in advance for your patience. 151 and 152. Chris, I'd like you to check these two out.
Are you going to play them for us, or?
Yes, they're about to come up on the other computer here.
Mr. Wilner?
Yes?
I'll just say that whenever you screen share, there's an option on there. If there's audio, you have to click share audio as well, because we won't be able to hear it unless you do that.
Okay, the first two, I perhaps can save the court some time. And I just wanted to confirm that the property where this took place is actually the 106, the defendant's property, where the co-defendants cohabitate together. That was the purpose of, I believe, 151 and 152. Let's just see. Is this playing?
I'm not seeing it quite yet. Oh, wait. Now we've seen stuff.
Oh, okay. No, these are the videos. These are not photos. Okay, this is weird. 151, please. Chris, I would like you to just watch this and we'll play it through once and then we'll go through again and you can describe what happens, please.
Your Honor, just for the clarification, I'm not certain if these were uploaded to Box or how they were transmitted to the court. If there was an upload, we did not receive a copy of that transmittal. Or at least I can certainly say I have not.
Okay.
May I respond, Your Honor, to that?
Yes.
These videos were previously uploaded and provided to opposing counsel for the January hearing. They certainly have had access to them. I also took the liberty of walking around the property with a video camera to show the position of these cameras and to prove that we are indeed across the street from 106, etc. And if Your Honor wishes, I'm happy to play that video for the court as well, which may aid in the understanding of everyone's apprehension as to where the cameras are located and what they're looking at. But these are all Ring security cameras that are installed at my property.
Did you take these? So these are from your cameras, Mr. Wilner?
These are captured by Ring.com. You can see the Ring.com logo up in the corner. You can see that they're all appropriately time stamped in the lower right hand corner, giving the date and the time of all of these incidents. And I believe, having looked up the case law, and again, I'm not an expert, but these fall well within the boundaries of accepted legal evidence for presentation.
Did you retrieve this information yourself from the Ring?
We uploaded it from the Ring account. They have not been modified. There's been no enhancements. We did take the liberty of making copies of some of these and zooming in if the court wanted to see more detail, if something was difficult to establish, but we did not upload any of those supplemental. These are all original source material.
Okay, all right. It does appear these were uploaded to Box. So, Mr. Wilner, please proceed.
You may all need to turn your, Laura, did you turn the volume on for this?
I had volume up on mine.
Yes, we were given an instruction by, I think, Monse about turning the volume back on. Join audio by computer. There we go. Does it take that over? Okay. Mute your microphone, please. Okay, I think, can everyone hear me okay?
Yes.
And there's no more feedback now? Okay. Chris, can you hear me?
Yes, I can.
Let's see if we have audio here. All the way up to let's try this. Can they hear me over there? Put the audio on, please. Can hear me. Whew, okay. Can you, sweetheart, please go back to the beginning of that and turn the volume on your computer all the way up, please. And the volume on the player. All right, full screen, please. Can you start it over? Pause for a second. So, Chris, can you please describe what's happening here in this scene right now?
I'm arriving to your property, and you're introducing me to someone that's working on the patio that's being built on the front of the property.
And who else are in attendance right there?
It's me, you, the worker, your two dogs. My wife and child are off camera to the right around the corner. She's still getting our infant premature baby out of the vehicle.
Chris, before this place, what was your experience during those months? How frequently you were at our property, and what did you experience coming and going from our property?
For a while there, we were meeting weekly on Sundays to have a dinner for a 2 to 3 hour period. Every time we came by, there seemed to be drama, yelling, harassment, people pacing up and down outside of the property, staring at the property, things being thrown, all kinds of different things.
Okay, so Laura, let's proceed with this. Play this. Just describe this as it happens, please.
Yeah, so we're sitting there talking, and all of a sudden there's a thud, and one of the dogs is going to run over towards the thud. Turns out a golf club was thrown onto the property from across the street, landing between our two parties, you and I over there, and my wife and child by the truck. Billy Sherwood comes over, try to grab his golf club. Roxy does a little circle there and then comes back to you. They stay on the grass and on the property right there. We go up and let the dogs and call them back, and then allow Billy to come over and grab his golf club after my wife walks away.
Okay, and can I ask you just for the record, as a top-notch dog trainer, how would you describe the performance of my dogs in this situation?
It seemed adequate. They didn't go into a bark and hold or do anything unnecessary. They did immediately respond to the intrusion of the property and go investigate, and they were under verbal control.
Okay. Let's proceed, please, to P152. Pause that, please, Laura. Your Honor, this is the camera on the parking lot that provides a different angle of the same incident, and it'll give you a better view of the item being thrown across the street from the trailer property at 106 West Wheeler. Chris, feel free to describe the series of events as they take place here. I may interrupt you with additional questions.
So wife is getting the baby stroller and all the baby stuff here.
Sorry, you're breaking up, sir. Can you repeat that?
Yes, I'm sorry. My wife is getting our baby and all the baby equipment out of the truck. She's loading it onto the stroller so we can take the baby inside. Mr. Chitwood comes up to the end of the property with a golf club, lines up facing us in our general direction, and begins swinging the club. I'm not sure if he's taking practice shots to hit rocks. I really wasn't paying any attention until the golf club came flying.
Okay, so Chris, and for everyone else watching, please describe Mr. Chitwood's orientation and what would your interpretation of his intent watching his activity before releasing the golf club onto my property.
He can't speak to what the other guy was thinking or his intent.
Okay.
He cannot. Okay, so please go
Okay.
ahead.
Is it all right? Laura, please continue. Okay, Your Honor, we could probably save time. There's about another minute here showing essentially the same information that we saw before. And just
I'll just let it go for just a minute.
Okay.
See it from this angle then. So at the front, on the far left in the hat, Mr. Wilner, is that you?
yes, in the hat. That was me, Your Honor.
All right. Okay. All right. Thank you.
So I don't want. I'm not. Well, I don't know what to say, but I would like to say that it seems very obvious to me, and I am. Can I?
Just hold on 1 second, guys. I'd like to do a dramatic reading of his folder names. We have work folder, rental agreed, city council, box exhibit upload, contempt, and gray reed dairy, legal document, bank receipts, bank transfers, bluefish, camera uploads, car docs, city council, contempt motion, DA. Also, this video that they're over on here says pulling up at 2:07 and talking about offing, unaliving somebody. Anyways, let's continue.
I share my impressions of this event since I was also witness at the time, or is that inappropriate right now?
Why don't you wait and you can testify? Let's get to your witnesses first.
Okay,
And
all right.
talk about things, be your personal
Okay, so-
impressions, but I don't want to kind of mix you in with other witnesses. I think it's going to get too confusing.
Okay.
So we'll give you a chance to talk a little bit later. Yeah.
Yes.
Do you have anything else for this witness, Mr. Wilner?
Yes, I do. I have the more serious event that actually took place later in the day involving a weapon. Let's take a look at, actually, I have a minor thing when Chris first arrived. Let's take a look at P153 very quickly. This, Your Honor, just goes further to Mr. Tate's assertion that there was always drama whenever they came and left our property for a number of months.
I assume this is the same day, Mr. Wilner?
It is, Your Honor. These are all the same day.
What day was this?
This was, you can see the date code in the bottom right. It was the 27th of March.
3/27/22. Is that right?
Yes, Your Honor.
Okay. So these things occurred on March the 27th of 2022?
All three of these did.
Okay.
And once these are done, we can release Mr. Tate to go on about his day as well. So, Chris, can you just speak to this? This is when you arrived. I don't know when this. I may have made a labeling error. Oh, it's when they. Okay. Yeah, here we go. So those are the Chitwood brothers. One of their most common efforts to annoy is to idle that truck for sometimes half a day at a time, playing loud music, and also to drive continuously around the block, and also to do burnouts. Back that up so they can hear the burnout again. This has went on for the better part of 8 months. Yeah. So speeding up and then stomping on the brakes or sharp turns, reckless driving through all around our property. Let's move on to exhibit number 155, please.
Mr. Wilner, did you admit 151 into evidence? You need to do that.
Oh, yes. I would like to admit all of these into evidence, please.
No, you don't want it. You got to, all of these is not going to work. You got to tell us which ones you're admitting.
Yes,
okay?
I'd like to enter plaintiff exhibits 151 and 152 into evidence, which we previously had Mr. Tate comment on. I would also like to enter P153 into evidence, which we've all just viewed together. Next, I would like to enter P155 into evidence. And in this case, I would like to request that Mr. Tate will watch it through together once. And then
they're not admitted yet, okay? You just offered them, but they're not admitted. And Mr. Savage may have some things to say about that. So, or he may not, I don't know. Mr. Savage?
I want to be clear on what's being offered. I've seen 151 and 152. I don't think and then there's a third video, and I'm not certain which number that third video was. Was that may help me figure out?
Yes, Your Honor. 151 and 152 were the golf club incident, and 153 was the truck idling and burnout incident.
Okay, so those are the ones. So let's hold off on 155 because you haven't shown it yet. So he's offering into evidence Plaintiff's Exhibit 151, 152, and 153. Mr. Savage.
I have no objection to 151.
It's admitted.
And with respect to 152, I have no objection.
It's admitted.
With respect to 153, I would object for lack of foundation date, sufficient foundation to understand what we are seeing and whether it is what Mr. Wilner reports it to be.
I agree. 153, I'm going to sustain the objection to it. It's, or I'm sorry, 155. Sorry, which one was this, Mr. Savage?
150. I understood that third video with the truck to be 150.
The truck? 153?
153.
Yeah, I agree on that. So we admit 151 and 152. 153, I sustain Mr. Savage's objection. It is not admitted. Please proceed, Mr. Wilner.
Okay, I would like to enter into evidence Exhibit P155.
We might need to see a little bit of it first, because I don't.
Okay. So, Mr. Tate, we're going to play this. Please, actually, for the court's benefit, let's watch it through once, and then we can do it again, and you can provide commentary. Okay, sir?
Yes, sir.
Volume all the way up, please. Okay, Mr. Tate, can you describe the chain of events here as we play this again, please?
I'm leaving your apartment. We're about to go home for the night. My wife has the baby in the stroller. As we walk out the door, we hear Jason.
Mr. Wilner, I cannot get the witness's testimony and the video playing at the same time.
Yeah, we can't. It's just too hard. Why don't you just, you know what, you don't need to play it right now. Just stop it right there, and Mr. Tate, just tell us what's going on here. That would be helpful. We don't need to try to hear both, because our court reporter can't take down two things at the same time. And that video is pretty garbled. So, Mr. Tate, just tell us what's going on here, okay?
Yes, Your Honor. We're leaving Mr. Wilner's house. My wife's carrying the baby. We're walking out to the truck. Jason yells, do you want me to get the gun? Billy says, yeah, grab it. It's in the car. Let's ride. So as we approach the end of the building there, the walkway, Billy yells across the street very loud. I finally get to shoot someone in this house. He then proceeds, as we're walking up to the truck, and you can see this from multiple angles, but he walks around the truck, opens the driver's side door. He pulls out an AR-15 platform rifle. He racks the slide and closes the dust cover, and then places it back inside the truck. He turns around, throws his arms up in the air, and says, stop.
Says what?
Stop. Like, what's up?
Oh, what's up? Okay. And who are these people, Billy and Jason? Who are they?
Sorry.
Not
I don't
really.
understand. What are their names? Who are these people?
William Chitwood.
Okay. And who's the other one?
His brother, I believe it is.
Who was racking the AR-15?
Billy Chitwood. William Chitwood.
All right. Thank you. You may proceed, Mr. Wallner.
Okay, so just to clarify, Chris, it was both William Chitwood and Justin Chitwood, who's a defendant here today, who yelled at you and your wife from across the road. Is that correct?
That is correct. Yes.
Okay. So is this the point where I ask if this is accepted into evidence, Your Honor?
Yes, you may. You have to offer it.
Yes, I'd like to offer this as evidence.
Okay, and what are you offering?
I'm offering proof of.
No. What's the exhibit number?
Oh, I'm offering exhibit P153. Oh, sorry, P155.
Okay. All right. Any objection, Mr. Savage?
No objection to P155.
It is admitted.
Okay, I would like to now offer into evidence exhibit P157, play that for the court, and then have Mr. Tate comment on that as well.
Okay.
I believe it's 157, Susan. No, you have to do the other one first. I apologize. 156.
And Mr. Tate, when you're commenting on these, rather than using just first names, if you could, sir, if you know the first and last names of these individuals who you're observing their actions, if you could use their first and last names, that would be helpful. If you don't know them, you don't know them, but if you do, it'd be helpful. Okay, sir?
I'll do my best, Your Honor.
Thank you very much.
And I can also add for the record, just for the ease and clarity of the clarification for everyone in the court, that the only two people that will appear in these videos are, in addition to my witness and his family, are William Chitwood and his brother Justin Chitwood, who's the defendant here today.
Okay. Please proceed, Mr. Wallner.
Yes, so we'll get back to exhibit 157. I would like to first offer into evidence exhibit P156. Okay. I'm going to just ask you to Your Honor, what I'd like to do, there are several noticeable things that I would like to point out to the court, in addition to relying upon Mr. Tate's evidence. In particular, the sound of the slide being racked on the AR. Would it be appropriate for us to replay this and draw your attention to the moment when that happens?
So the brother, it sounds like the brother racked the AR, not the defendant.
Not the defendant. my understanding is that they're both complicit in making the threat. And so I just wanted to have Mr. Tate describe what, in his accomplished opinion, that threat was and whether or not it was real, and to the degree that it was real for the court.
But who said I'm going to shoot somebody today? Was it the brother or was it the defendant?
It was both. The louder one is William Chitwood.
Your Honor, no, it was not. I object.
Yeah, you can't. Mr. Chitwood, hang on a second. Hang on just a second here. We'll get to you, Mr. Chitwood. I know you've got a lot to say about this. But I'd like to go on it instead of Mr. Wilner testifying. We got to keep this in order now because you can see what's going to happen if we don't. It's not going to be good. So let's let Mr. Tate testify as to what he observed, not what his views on other people, and then let's go on to let's try to get this one admitted, and then let's go on to the next exhibit. Okay. All right.
Please proceed with your recollection, Mr. Tate.
So as we're approaching the vehicle again, I hear then I finally get to shoot someone in this house. Let me see. We're walking towards the truck. I'm trying to get back on track here. And as we're approaching the truck, I'm concerned because of the statement that was just made. And talk about the guns and then moving around the property. So as we come up to the back of the truck, I walk up behind my wife and then I quickly realize I can't really see anything from that vantage point, but I'm trying to stay behind cover just in case something were to happen. So then I reposition myself to the rear driver's side corner of the truck where I can see, but I'm close enough to cover. And I sit there and I observe, and I'm observing, he walks around the truck.
Who is he?
Sorry, I apologize. William Chitwood walks around the front of the truck, opens up the driver's side door. He pulls out an AR-15 platform rifle, racks the slide, closes the dust cover, and puts it back behind the driver's seat. And turns around. He looks right at me. He'll stop and throws his arms up in the air. I declined to engage him at that point. I wasn't trying to escalate or cause any problems. I'm just trying to see the safety of my family. So I remain in that position while they continue to do their thing. My wife comes over and tells me that the baby's in the truck and asks me what I want her to do. I told her to go and get in the truck. I watched for about 30 more seconds to make sure everything's kind of calm. There's nothing that's needing my attention or my presence, and then I decided I'm going to go back and let William Wilner know what just transpired outside of the property. And that's when William Chitwood begins to yell at me again as I start to walk away. He begins to yell at me. He says, "See that N-word over there? Me and him beefing because that N-word pulled a gun on me. Don't get in the mix, bro. Real shit. That's some shit between me and him. You understand?" So there's a pause, and then he's still walking and says, "You understand?" When he used that command language with me, it was very triggering. I turned around to go speak with him at the end of the property. I was not going to raise my voice. Again, I'm not looking to escalate, but I was looking to make sure that we had an understanding.
And this interaction, Mr. Tate, was with William Chitwood. Is that correct?
Yes, Your Honor.
All right. Proceed.
And if I may, Your Honor, this goes to the injunction against allowing threats, etc., or harsh levels of speaking to emanate from the property, which Ms. Chitwood was enjoined from. So I'd like to enter P157, P157 into, this is 156 into evidence.
Any objection, Mr. Savage?
To P156.
156.
No objection.
It's admitted.
I'm not sure about Mr. Chitwood, just to be clear. I'm only speaking to this party.
I understand.
And if Robert allows it, I will too.
All right. Very good. All right. Mr. Chitwood, let me ask you, we've had a few other exhibits here. 151, 152, 155, and 156, that Mr. Savage has not had any objection to. Have you had any objection to any of those, sir?
No.
All right, very good. Okay, so we're going to take our mid-morning break at this point, just to give our court reporter a break. It is difficult, and she needs a little rest. So we'll come back at 11:30, and then we'll proceed until noon, and then we'll take our lunch break, which is usually a 90-minute lunch break. Okay. All right. So at this point, we're taking a break until 11:30, and we'll see you back at 11:30. Okay.
All right, thank you, Your Honor.
Thank you.
Come back soon, I promise, but can you hear my popcorn popping? Come on. Oh, come on. Okay, come on, G. If I touch it, it will literally just fuck it up. So I just resist doing this. Because it's gonna. Fine.
With William Chidley.
And that's 157.
It's 157, Your Honor, yes.
Why don't we hold off on offering it until after we've had a chance to look at it? Okay.
Oh, okay. I'm so sorry. I didn't realize that was a protocol. I'll do that in the future.
Yeah, sometimes it is, sometimes it's not. We're going to do that with this one just because of the way the evidence is coming in.
Your Honor, nothing else happens in this video.
All right, so why don't you start asking Mr. Tate some questions about it, and then we'll see if we can admit it, okay?
Okay, so Mr. Tate, can you describe the events that just transpired here in this video, please?
Yeah, so this video picks up more or less where the last two videos ended off. William Chitwood had just asked me, do you understand? Or yelled it to me, I should say. At this point, I walked over to the end of the property line over there because, again, I didn't want to raise my voice or do anything escalatory, but I wanted to speak with him, make sure that we did have an understanding. As he comes walking up to our property line, he crosses the street and walks up to the property line and says, "Sup?" And I said, "Let's get something straight." And he said, "Okay," or "All right." I said, you said he pulled a gun on you. And he said, "Word." And I said, "You're out here swinging a rifle around and talking about telling me not to get in the mix." And his response was, "Yeah, on private property." And I said, "You're yelling about shooting somebody, you're armed with a rifle." And he walked away. And as he's walking across the street, he turns around and he yells back, "You know what? I got 3 of them, though." And I said, "Okay, that's great." Because at this point, it's becoming clear that he's just trying to threaten me. Having 1 gun or 3 guns doesn't really matter. That's great. I hope you're an expert marksman. And he says, "Oh, I am." And I say, "Good." He gets in the truck and then he says, "You can ask something about my shooting."
Your Honor, I'm going to object to the extent that this is involving hearsay, out-of-court statements by someone who's not present, and to the extent that the hearsay is not admissible.
All right, sustained. Go ahead, Mr. Tate.
And then at that point, I yell, "Okay," as he's about to take off, and then he rolls down his window and yells, "Yeah, as a matter of fact, my name is William Chitwood. Do a background on me."
Objection to hearsay as well.
Sustained. Go ahead, Mr. Wilner. You have any other questions for this witness?
Yes, I do, Your Honor. Sorry, Chris, were you finished, or did you have anything else to add?
Well, at that point, I just wanted to add that he did the typical thing, which was rev up the truck and burn out and kill down the streets, which was very typical when I was around.
Okay,
Right.
thank you. And also, I just with regards to the objection, I believe the video speaks for itself when William Chitwood yelled his own name and said to look him up. So, now,
That's the argument.
Yeah, we don't need to get into that, guys. It's neat. Like the Germans say, it doesn't matter.
okay,
What matters, you need to get your case on Mr. Wilner. So keep
yes,
that.
I'd like to enter this into evidence if I may.
All right. Any
Yes, sir.
objection to 157?
Could I be permitted a very brief, honestly very brief line of questions about the evidence admissibility to Mr. Tate? It's being offered, I understand, based on his testimony. I want to just clarify something briefly.
I come on board after this. Go ahead. You can ask a couple of questions.
Thank you. Mr. Tate, have you ever seen this video before?
Yes, I have.
Okay, thank you. I have no objection.
All right. All right. Mr. Chitwood, any objections, or are you going to go with Mr. Savage on this one?
I'm going with Mr. Savage, Your Honor.
All right. It is admitted. 157 is admitted to evidence.
Excellent. Mr. Tate, a couple of quick questions with regards to the weapon. It's been alleged that it's not clear to make out the weapon at the camera angles. I'll be presenting evidence from others to that effect very soon. How are you so certain that the weapon produced was not a replica and was in fact a functioning firearm?
Objection. I don't think that the issue. I think there's a question of relevance here, as well as a lack of foundation for expertise. We talked about his background, but I think he needs to illustrate a little bit more his understanding of differences between weapons and how he would know that it's not something that.
Hey, Mr. Savage, you're right. But are you serious? Okay. All right, Mr. Tate. I mean, really,
Yes, John.
we spent an awful lot of time here, Mr. Savage, on did your client get notice? And she did, right? So now we're questioning this man who's been in the Army. He's an expert marksman. If he knows what an AR-15 is. All right, so we're going to go on because this is what you want, Mr. Savage. I'm telling you, it's an issue right now. So
Respectfully, they're very serious allegations, and
They are.
I'm interested in defending my client and making
I
sure that he
understand.
has an opportunity to test the evidence and make sure that Mr. Wilner proves his case if he's able to prove it. So I
It's a credibility issue at this point, and I hear what you're saying, and we'll go on. Let me ask Mr. Wilner. Mr. Wilner, you're going to need to ask a few more questions to Mr. Tate, who's been in the Army, how he knows that this was an AR-15 and not a replica. So please give some more information about his background from him, if you would.
Yes. Chris, what steps do you currently take to maintain the currency of your knowledge and expertise as an expert marksman in the multiple platforms that you previously described?
I'm a member of an elite group membership at the range in Austin. I'm a member of the Patriot Club. I train there on a very regular basis. I put more than $5,000 a year into my firearms education, continued shooting knowledge, and access to various weapon platforms. So I actually have an AR-15 here in the room with me that I can demonstrate all of these things as well, if the court would like to see any of that.
What's the difference between a replica versus a functioning firearm, and what are the precautions that have been codified into law to establish the rapid differentiation between the two?
Well, we have dummies, replicas, and then toys, and then firearms. Replicas are designed to look like the real thing, but they don't have functioning parts. Dummy weapons are usually hard rubber. Again, there are no moving parts. Anything that is brightly colored or a toy should be brightly colored. It should be clear, or it should have a orange, red, and blazed barrel. Is my understanding according to federal law. And the weapon that was shown to me was metallic. It had functioning parts, and it charged, and the bolt slammed forward. Which is a very distinct sound for anybody that's ever worked with a firearm. That's a very distinct sound, one that personally causes me a little bit of stress.
What other actions did he take?
Your Honor, I'm satisfied. I have not heard this before, so that's what I needed. I have no further objection.
All right, very good. So 157 is admitted. And we've already admitted that. And I believe now what we're going to do is Mr. Wilner was questioning Mr. Tate pertaining to, or wait, was it admitted? I'm sorry, I'm a little bit mixed up. Exhibit 157, if there's no objection from either Mr. Savage or Mr. Chitwood, is admitted. Okay? Do I have any objection to 157?
No objection from Ms. Curry.
Okay, Mr. Chitwood.
I'm rolling with Robert from here on.
All right, thank you. I'm going to keep asking you for the
Just
record.
save time.
Yeah, no, I appreciate it. All right, so then let's go back to it again. So 157 is admitted. Mr. Wilner was going to ask Mr. Tate some questions. Please proceed, Mr. Wilner.
Okay, yes. So what did you do after William Chitwood yelled, "Look me up"?
Later that evening, when I got home, I looked through the Texas Department of Public Safety public records, and I pulled and paid for a copy of his arrest history and charges.
Would you mind please giving the court a quick summary of that? And I note the irony when I say quick summary.
I object to that as hearsay.
Yeah, the objection is sustained. And I'm also wondering a little bit about the relevance on it. Mr. Wilner, you've got lots of good information here, with people throwing stuff on your property and yelling. We don't need to bring in criminal record of a person, the brother of the person who's the defendant.
Okay.
He may have a terrible criminal record, he may not, I don't know, but that's not relevant to our talk today. Please go ahead.
Okay, and just for the record, I was only bringing this up to show that this person was a very constant presence at their property and engaged in this sort of behavior over a matter of years, and this could not have happened without the defendant Tracy's knowledge and acquiescence. Moving on to, so after, Mr. Tate, so after this took place, and I don't want to give evidence here, can you describe what steps we took immediately after this event regarding Maynard Police Department?
After I spoke with you, we agreed it would be best to go ahead and contact the Maynard Police Department and to file a report with them. They came out and took the report. I asked them, because someone had a rifle and was bragging about going to shoot somebody, if they were going to do anything to try to intercept them or prevent a crime from happening, and they said that they weren't going to do anything.
Object to the hearsay.
Yeah, I sustained.
Okay.
Mr. Wilner, try to keep him what he said or did
Okay.
rather than the actions of others who are not here. Okay, go ahead.
Yes, Your Honor. We sent in an email to the court, which Monse will have, which provides a summary of the individuals involved with Maynard Police Department. This goes to your question to me earlier about why did Maynard Police Department not provide proper assistance in a situation as dramatic as this one was and as emergent as this one was. And we would like to enter that into evidence. It is P168, if you would like to take a moment to look at that. I would like to ask Mr. Tate to describe the frustration that he took in his quest to try and see some action on this out of his concern based on his expertise as a war veteran, if that's acceptable.
Yeah, he can talk from his own experience.
Okay. So while there, did you want him to proceed with that while you're pulling up?
Yeah, I'm doing my best, but there may be some objections. We don't see it right now, so why don't you ask him more questions, okay?
Okay.
I have not received an email. If there was one just sent from Mr. Wilner, just want to make sure that we have an opportunity to see that as well.
I haven't seen it either, so he may have sent it, but I haven't seen it yet. So,
Thank you.
Mr. Wilner, did you send this this thing about the Maynard Police Department? Did you send this to Mr. Savage?
Can you give me the exhibits list, please? Thank you, sweetheart. Towards the end.
So, Mr. Wilner, before you spend too much time on this, let me just say this. The fact that Maynard Police Department did or didn't help you, in some ways it's not relevant today, because the thing is this, you said, hey, I ran for city. They used to help me. I ran for city council. They stopped. I bet you brought someone in from Maynard Police Department, they'd say, oh, that's not the reason at all. We don't know. What we really know about today, what Mr. Savage is here and his advisor pending, is that court order back in August of 2021. What have these parties done to violate it since that time? That's all we need to know about it. Maynard Police Department, it's honestly not that relevant to us today.
Okay, thank you, Connor.
With that in mind, just try to keep that in mind. Let's proceed, okay?
Okay, thank you. So, Chris, just can you then, we're pretty much getting towards the end of your testimony, but given your experience in making immediate, and I don't want to be overly dramatic, but genuinely split-second decisions in situations and having interacted with a lot of people in various states of mind during your tour of duty, what would your accurate assessment of that situation and its degree of emergency be?
It was a volatile situation, I believe. I believe that he was making it known that he was being or ready to be violent, that he was armed, that he was loud, he was dominating the area. I'm sorry, what was the question?
And so the degree of emergent risk.
I contacted the police department, and then I followed up the next day. I got the special operations division involved and the supervisor's number. And I also contacted several other federal agencies because I was concerned about the lack of response and the immediacy of the situation.
Okay. So I think that will do. And Your Honor, I just wanted to point out that the reason why I asked Mr. Tate these questions is because he's not a casual observer from the street.
No.
If he thinks that it's a serious situation, then my tendency is to agree with him.
I'm in a hearing right now. All right, thank you. Anything else, that you have, Mr. Wilner? Or are you ready to, let the others ask some questions to this
So
witness?
let the others ask some questions with
right.
the option of clarification after the fact if need be.
You'll have a chance, as long as it stays within what the topics you've talked about or they've talked about, you'll have a chance. So, Mr. Savage, do you have any questions for Mr. Tate?
Yes, ma'am. Thank you. Mr. Tate, this was all these events that we've just gone through. Was that the exception of following up with the police department? Was that on March 23rd, 2022?
I don't remember the exact date. I feel like it was later than that. I feel like it was the 28th or something, but I don't have that written down.
Okay. And have you ever met Miss Tracy Curry?
I have not.
Was she out there on that date that we've been talking about during the event?
There are numerous individuals trafficking back and forth between that property on foot. I don't know any of them by name except for the ones that have announced themselves to me, and that was caught on video.
Okay. And that was William Chiblet, I believe. Is that right?
That's who he identified himself as, yes.
Okay. Was this the only date that you were involved with any issues at that property, or were there other dates?
I was witness to constant yelling, harassment, burnouts. It was a constant thing every time I was there. It was a weekly basis.
Okay, thank you. No further questions.
All right, thank you, Mr. Savage. Mr. Justin Chitwood, who's also pro se, do you have any questions for this witness?
Not right now.
All right. Very good. Mr. Wilner, do you have any redirect for this witness?
Yes, Your Honor. Very quickly, Chris, just to confirm with regards to opposing counsel's question about the date, I don't know that an objection is necessary, but I believe the question is moot because the date of the events is clearly time-stamped on the videos, so that should address that issue. And when you say that you were a witness to events of harassment on a weekly basis, can you describe the number of weeks or months or how long that took place, over what period of time?
Over the better part of a year. I mean, honestly, it got to the point where we don't go over there anymore. That's the honest truth.
Right. So, is it true, in fact, that we now drive up to Buda to visit you instead?
That's correct.
Okay. All right. Thank you very much, sir. I really appreciate your patience and for staying with us this long throughout the proceedings today. Thank you very much.
Thank you.
All right. Mr. Savage, anything else?
Oh, ma'am.
Mr. Justin Chitwood, anything else?
No, ma'am.
All right. Mr. Tate, I do have a couple of questions for you. So You were going to Mr. Wilner's home with your wife and infant child as a guest. Is that why you were there?
That's correct.
Okay. How frequently, or when did you start going to his residence, if you can recall? What year?
Believe it was roughly a year and a half to 2 years ago. I don't have the exact dates. And we went over there on basically a weekly basis. I even started doing some training out in Manor, which William helped facilitate. And so after those training sessions, we'd go over and finish with dinner at his house, and then it just turned into a weekly meeting thing, even when I wasn't doing training out there. And then that slowly faded away over the course of a year.
So let me ask you, this situation that's arisen with the neighbors that you described in terms of yelling and burnouts and things of that nature, has that situation existed the entire time you would go and visit Mr. Wilner?
Yes, Your Honor. I don't believe there was a time, honestly, where we were either not harassed ourselves or we weren't witness to harassment. Even people just while we're eating dinner, walking up the side of the property line in the street, yelling crazy things in the direction of the house. It was a constant vigilant state. And eventually I just didn't want to put my wife and family, my baby in that situation.
When did you stop going to Mr. Wilner's residence?
It's been some time now. I'd say over half a year ago, 6 months or so ago, we stopped, I think.
All right, so that would have been, let's see here, we're in March, September, December, October, September. So about since September of 2022? Mr. Tate, did you hear me?
Yeah, I did. I'm trying to think, Your Honor, honestly. But I'm guessing so something like that. It might have been earlier than that.
Okay. Does Mr. Wilner now come to your home in Utah instead?
Yes, ma'am. Yes, he does.
So you all are still friends?
Yes, ma'am. We don't meet on a weekly basis anymore, maybe once a month, but we still meet about once a month and over here at my house. My business has gotten incredibly busy, and I work on Sundays now, which I just don't have the availability.
And this situation that's arisen at Mr. Wilner's property, is that the reason you're not going to see him anymore pertaining to the neighbors, yelling, screaming, burnouts, things of that nature? Is that the reason you don't go there anymore?
That is the reason why we stopped going there, and he started coming to our house. And then as my business picked up, my availability on the weekends has dropped off, which is why we don't meet as frequently anymore.
What type of, to the best of your knowledge, what type of business does Mr. Wilner have at his residence there at his property across the street?
He hosts guests at the house as like an Airbnb or a short stay to medium stay rental. And so he has people constantly coming and going that stay for various amounts of time. I've met a lot of the people as I come over there on the weekends. They're all generally pretty friendly.
Have you ever personally witnessed either Tracy Curry Chitwood or Justin Chitwood harass any of the persons who are staying at Mr. Wilner's property?
I haven't seen a direct conflict as far as one-on-one individual conflict, but I do see them, walking real close to people's cars on the street over there by that side of the parking lot. I hear them yelling, especially facing the apartment and yelling. There's little backyards, balconies, and people spend time out there, and they'll just be super loud, which even inside I can hear them. So people outside obviously are being constantly bombarded by this verbal stimuli that could be aggravating over time.
All right, those are the questions. One other quick question for you. We talked about the golf club incident. There's also a fireworks incident. Were you present when fireworks were shot onto the property?
I don't believe I was, Your Honor. No, ma'am.
There was also a pellet gun incident. Were you present when the pellet gun was shot at the property?
I believe I met the mother, but I was not there for the incident.
All right, that's all the questions I had for you.
Your Honor, there was an answer you gave that I wanted to follow up on the question with respect to Ms. Curry.
All right.
Thank you. Mr. Tate, earlier you testified, if I remember correctly, you had not met Ms. Curry. Am I correct in understanding that?
Not to my knowledge. She has not approached me, identified herself, or introduced herself to me. I may have seen her in passing.
Okay. The judge asked you if you've had issues or previously seen Ms. Curry and Mr. Chitwood harassing you or others, and I'm trying to paraphrase as best I can.
No problem.
But you haven't actually identified Ms. Curry, is that right?
I've never said that I heard her yelling. I've heard yelling coming from her property and from people that she's had over at her property. But I don't know the names of everybody that yells or threatens or whatever from that property. But there are numerous individuals.
I appreciate your testimony.
Thank you.
All right. Anything else for this witness?
Not for me, Your Honor.
All right. Mr. Tate, you have exercised immense restraint, both in those videos and with us today, asking you questions. So thank you very much for your time today and for your service to our country. You may be excused. Okay.
Thank you, Your Honor.
All right, folks, we are now at the noon hour. We are going to take our lunch break. But before we do, Mr. Wilner, let's kind of get a little idea of the afternoon. Who are you planning on putting on this afternoon?
There will be no other witnesses except for myself and my wife. I'm hoping that we can make much more rapid progress through these exhibits. And I appreciate it. I'm fully aware that some of the lack of progress is just my experience with this. So I hope I've got the system down, or I understand how to proceed with this. And at this point, I just really want to prove up the rest of the allegations. They don't require witnesses to do so. The video evidence will speak for itself. And then, of course, towards the end, I'll certainly will provide testimony to support or buttress any of the assertions that we're making with the help of these security camera videos. And of course, we also would like to make statements with regards to the impact that these years of harassment and terrorization have had on us and our family and our guests. I did want to clarify just really quickly with regards to our business here. This is not a house, it's a fourplex. It's one that we purchased 4 years ago and renovated extensively into luxury apartments. We have hosted the chief operating officer of the.
They're nice. They're nice. Okay.
Yeah. I just didn't want to leave the court with the impression that we have a house here and that we've got, backpackers coming over and staying in the spare bedroom or something.
Did not have that impression. Okay, so here's what we're going to do then. We come back from lunch at 1:30. And we'll be hearing from Mr. Wilner and his wife. Mr. Wilner, remember, go back through your court's order and go back through the motion you filed. These videos are helpful, but hearing from you is helpful too. And actually, they're bolstering you. You're not bolstering them. Okay, those are videos. So just get through them for us, because we will have. I can guarantee you, Mr. Savage has quite a bit to say. I'm sure Mr. Chitwood does too, and they're entitled to time as well. So we definitely need to move through the rest of your information here. And then if we don't, I don't think we're going to be finished today. That's all right. You only asked for 2 full days. Thank you for doing that, both of you. Very thoughtful of you. So we'll get through it. But I think this afternoon, let's just try to get through. Mr. Wilner, you and your wife really figure out which exhibits you want to get through. I think given the way this is structured, we're probably going to have to keep looking at them a little bit first and then make a decision on whether they're admissible or not. I just don't know any other easier way to do that where we are right now. So that's kind of where we are, folks. We will take a mid-afternoon break. Our court order needs as much as I do. And that's where we are. All right. Thank you all. You may be excused for lunch, and we'll see you back at 1:30. Okay?
Thank you, Your Honor.
Bye. All right, good afternoon, everyone. I hope you had a nice lunch. We had a judges meeting that ran a little long, so that's why I'm running a few minutes late, and I do apologize for that. All right, so where are we? Mr. Wilner, I believe, was he had finished his witness for the morning. Mr. Tate, and then he and his wife were going to be presenting testimony this afternoon, is what I recall. So, Mr. Wilner, you may proceed.
Thank you, Your Honor. Being very mindful of your admonition that the exhibits are here to support our testimony and not to be overly reliant upon them, we've taken your instruction and we will not be presenting anywhere near all of the evidence that we have uploaded. I think we have struck off approximately half of these exhibits. And we will, with your permission, request just that you let us know at any time if we've proved a point sufficiently that we don't need to belabor it, because it's not our intention to waste the court's time in that manner.
I can't let you know if you've proven it or not, but I can certainly let you know if it's become repetitive.
Okay.
The proof is not, I need to hear from everyone before I make some decisions on that. So please proceed, Mr. Wilner.
Okay, so I believe it's already been established for the record that the previous judgment or default judgment was issued and the defendants were properly notified. We have, in our motion for contempt, we have made some allegations. I'm going to run through the explanation of those very quickly and present my exhibits in support of those assertions.
Okay.
One of the ones that Your Honor asked for already from Mr. Tate, my evidence, or didn't ask him for, but asked if he had been a witness to, was the fireworks incident. I would like to present a brief description of the events of that day and then some exhibits in support of my testimony. I will mention as an aside that Your Honor inadvertently referenced this incident in another manner when you asked Mr. Tate if he had also witnessed the shooting of one of our nursing mother guests by a pellet gun from across the street, which he did not witness. However, in the process of several hundred pellets being fired at our building, and in particular at one of our security cameras, that security camera was damaged. And so we will be missing one piece of evidence in the form of the parking lot camera footage on the day that the fireworks were fired. So I want to forestall any objection or any question with regards to us not having that evidence. We have certainly collected a number of projectiles that were fired at our car and at our camera and at our building by the Chipwoods. So with that being in mind and dealing firstly with the fireworks incident, I would like to present P003. No, sorry, 1 second, my apologies. P006,
Okay.
which is a video of William Chitwood firing fireworks directly at a house.
Okay.
Pause that for a moment, Laura. I will say, Your Honor, that we did not know that this was happening. We were away from the property at the time. Otherwise, obviously, we would have. Those, by the way, are Afghani refugee children that we provided shelter to after Kandahar fell, and that family was with us for some 6 weeks. We obviously would have gotten the kids out of harm's way immediately if we had actually been on the property. We did not find out about this incident until we received a call from a neighbor and went looking through our video footage in order to find what was available.
Okay.
Let's proceed now. Laura, go ahead and play that, please, for the court. I want to direct your attention to the upper left corner of the screen.
Okay.
For the video, I'd like to make an objection.
What's your objection?
Mr. Wilner has testified that he was not there at the time. I'm not sure how he is able to lay a foundation that this fairly accurately represents something that is within his purview. If there's somebody who's there who witnessed this that could provide additional information, I think that would satisfy my objection, but I'm not hearing that from the testimony he's offered thus far.
Yes, and I'll reply to that, Your Honor. We returned while this was still underway. My comments about having to go look for this information and retrieving the children, we were in fact back in time to begin making a phone call to 911, during which I provided an extremely accurate description of the individual, including down the details of his vehicle, and I'll be playing that 911 call for the court as well.
All right, please proceed. The objection is overruled conditionally. We'll see what Mr. Wilner puts on. Mr. Wilner, please proceed. We'll see if he can lay a foundation for this.
There'll be some more fireworks in this one, Laura, or is that at the end? There's 007 also. No, there are more. Yeah, so you can see now there's another volley. You might refer to it as a Roman candle, a number of projectiles that are stored in a tube that fires sequentially.
I see it, yeah.
That's sufficient, Laura. We can pause this. So, Your Honor, let's go ahead and so there's another video showing additional fireworks being fired. We can play that followed by my 911 call, or we can play the 911 call first, whichever you prefer.
Let's hear the 911 call. Maybe that'll give me some more context here, because I'm struggling with that a little bit.
Okay, so this is exhibit P012.
Travis County 911, police, fire, or EMS? What address or location?
It's a 200 block of West Wheeler. There's an individual in a red t-shirt, red socks, about 5'9", 110 pounds, firing fireworks indiscriminately at random buildings.
May I get a call started that way so we can have our units prepare the call here? Alright, firework violations. And is he directing them at buildings, or is he just in the street with it?
No, he has fired them indiscriminately at buildings, in the air, off the ground, in multiple directions.
Okay.
So he did specifically aim one directly at a building for at least 4 discharges.
Okay, got it. Are you wanting to meet with our units at all?
I do not want to be identified or meet with units. I already have problems with these neighbors, and I don't need them to escalate.
Okay.
However, if this matter does escalate, you can email me, and I'll be happy to forward footage from the security cameras.
Okay, unfortunately, I don't have any access to receive any emails or anything like that on my end. For the gentleman that's out there, can I get his description again? Was he white, black, Asian, Hispanic?
He's brown skin, but light brown. He's wearing a red t-shirt, red socks, and a red cap, black shorts, tennis shoes.
Gotcha. He's had a baseball cap?
Yeah, baseball cap. About 5'9", maybe 120. Slight build, dark hair, next to a brown and black extended cab pickup truck.
Okay, gotcha. Alrighty, I will get my units out there to check on that for you.
Thank you.
Okay. Okay.
All right, do you seek to have this admitted into evidence, Mr. Wilner?
Yes, that is P10 that's right, P012.
All right. The objection, Mr. Savage.
What date is this 911 call made, and how has he retained or obtained this information? There's no sort of identification that helps us understand a little more context about this 911 call. So I'm speaking in objection. My apologies, but I'm a little bit hindered because I'm dealing with a pro se questioning himself. But
It's difficult. It's a difficult thing, but we're going to make it through. So, Mr. Wilner, was that 911 call, was that made on January 1st of 2022?
Yes, ma'am, it was. We have not uploaded a copy of our Freedom of Information Act request, which we used to obtain both that 911 call and a second one that we made later on the same day when Chip was once again firing fireworks at buildings and through an intersection with passing cars, etc.
That satisfies.
Does that satisfy your concerns, Mr. Savage?
Yes, Your Honor. Thank you.
All right. So, Mr. Chitwood, any objection, or are you going to go with Mr. Savage on this one?
Nothing right now.
All right. It's admitted. Also, just to clean up the record, P006, Mr. Savage had an objection, but I think that was just cleared up by Mr. Wilner providing a little more context. And that was the video that had the Roman candle off to the side. Mr. Savage, do you still have an objection to P006?
We would dispute the characterization of it containing video footage of a Roman candle, but yes, we have no objection to that footage, P006.
All right. Mr. Chitwood, are you going to go with Mr. Savage on that one, or do you have an objection?
Yes, ma'am, Your Honor.
Okay. Yes, you're going to go with Mr. Savage?
Yes, ma'am.
All right. All right. Very good. Mr. Wilner, P106 and P006 and P012 are admitted. Did I get those exhibit number rights? Exhibit number correct? Okay. All right.
We have an additional piece of footage showing another instance on the same day where additional fireworks are being discharged towards buildings. This is P007, which I'd like to play for the court and have it entered into evidence.
Let's take a look at it. Where am I looking?
Ma'am, you're looking from what's called the stairs camera. It's on the second floor balcony. Oh, look to the upper left of the corner, please. Same place.
All right.
I'd like to point out for the record that my description of Billy Chitwood, according to his arrest records, is accurate to within 5 pounds of his weight.
Okay.
This may become relevant on the record in future issues with the Maynard Police Department. This one, I believe this is more shot across the ground. Okay, that's all there is for that one.
Okay, I didn't see anything in that one, so.
Yeah, it's up here, and this was a different type of projectile that fires little smaller sparkles, which is the staticky pop 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 sound.
Yeah, I just didn't see it. All right, so.
I believe that the first one, if this is not acceptable as evidence, I believe the first one, having already been admitted, serves as sufficient evidence.
All right, then let's move ahead. This one didn't show anything. So.
Okay.
All right.
I would like to submit a second 911 phone call that took place on that same day. This is 013.
Travis County 911, do you need police, fire, or EMS?
Police, I called in earlier about a fireworks violation with someone deliberately firing Roman candles at houses on the 200 block of West Wheeler earlier today. I want to report two things. One is that the police officers did show up, drove right past the individual without stopping to question him, and that this individual just set off several more Roman candles, and again was aiming them at houses.
Okay. I have an address from your same phone number at the 200 block of West Wheeler Street in Maynard?
That's correct.
Okay, let me get it closer out there.
The address that they're in front of is 207.
Okay.
Now, it's dark now, so I can't give you a positive idea. I gave you a detailed description. The person was dressed very uniquely with a red hat, red shirt, red socks, black shorts, and black shoes. I gave height, weight, and approximate age. And the vehicle that the person was standing next to, so there's no reason why the police should not have stopped and spoken to that individual. He was standing next to the vehicle, and they just drove right past him. I can't say for certain that it's the same person who's doing it again, or who's just done it again, but I am noting all this. I did offer to send a video of the incident earlier, and whoever answered the call then did not accept that offer. I have the video from earlier. If something happens on this, it's definitely going to be on those officers for not interviewing.
Okay. If you did offer another call taker can't take video, but I do have a call to that area. Did you want to meet with him at all?
No, I'm not interested in meeting with the officers on the street, but if there's an email address that I can forward the video to, again, I was disappointed that whoever took that wasn't interested in the video. Clearly showed the individual that would have allowed them to make a dangerous activity or what's the word I'm trying to think of here? At the very least, it would have allowed them to issue a warning. Certainly would have been sufficient to issue a citation because it's a very unique dress operations.
Okay.
So I'm just calling it just to let you know that it's happened again. And so if somebody's house catches on fire, then there's going to be house pay.
Did you want to leave a name or number?
No, that's fine. I mean, you can. I'm happy actually to leave a name and number. It's William Wilner, 832-774-2533. But I'm not interested in meeting with the officers on the street.
Okay.
I'm not trying to have this. I mean, these are people that have been problematic ever since we've been active in the community. But clearly, this person is deliberately firing these Roman candle, multiple exploding shells from these Roman candle baker's dozen fireworks directly at houses.
Okay. Alright, I've got all the information while it's on the card. Alright, well.
Thank you very much. Bye-bye.
Thank you. Have a good night.
My testimony in response to, first I should ask if this is acceptable. Can I enter this as evidence?
Offer it into evidence and let's see.
Let's offer this into evidence, please.
All right, and what are you offering into evidence?
P013.
No objection.
All right, Mr. Chit, what are you gonna go with, Mr. Savage on this one, or do you have an objection?
Yes, ma'am.
You're gonna go, you don't have an objection?
No, ma'am, no objections.
Okay, all right, very good. Mr. Wilner, P013 is admitted.
Okay, thank you very much. Your Honor, being mindful of your admonition not to make a repeated reference to Maynard Police Department, I would, just for the record, like to very quickly offer P008 into evidence so that it is on the record when I get a copy of these proceedings. This is a fraudulent police report where they claim that they were unable to locate the suspect despite the description. I will refrain from offering into evidence video of the police cruisers stopping while William Jacob was actually obstructing their passage.
I'm sorry, while what?
While obstructing the passage of the police cruisers, two separate police cruisers pulled up, slowed down because William Jacob was still in the road in the dress that I described next to the vehicle I described, declined to stop and interview him. And then the officers, you'll see on page 4 of this, their official report, they entered that they were unable, or sorry.
Okay. All right, Mr. Savage has, actually, I don't know that this is hearsay. I don't know that it goes to prove the truth of the matter asserted. Why does it, Mr. Savage?
Unable to, there it is right there.
Why, Mr. Savage?
Mr. Wilner was beginning to assert some facts from this report that he is, I understand, to be using to substantiate his arguments regarding why he's needing to try to do everything he can to address the situation at hand. And that involves his attempts to work with the police. And so in that respect, I would object. Mr. Wilner here is attempting to introduce a police report containing multiple pages of records where there is nobody from the police department here to testify. That is hearsay. We would object on this.
Okay. I don't know if it is. Yes, Mr. Wilner.
I would respond by saying that it's clearly not hearsay. These are sworn official documents that were obtained through a FOIA request, and they're part of the public record. I don't think that meets the definition of hearsay at all. And if opposing counsel, I've already said that I'm not going to abuse the court's patience by introducing the video, watching the police refuse to respond appropriately. And if you want me to withdraw this, I would ask that P008 be entered into evidence, please.
Okay. All right. Mr. Chitwood, do you have anything? Are you going to go with Mr. Savage on this one?
I'm going to go with whatever Mr. Savage says.
Okay. All right. Well, given the explanation that we have received from Mr. Wilner pertaining to the use of this record, I do believe this is hearsay with the further explanation he gave. Therefore, the objection is sustained, and this exhibit will not come into evidence. And what is the number of this one, Mr. Wilner?
P008, Your Honor.
Okay, so P008 is not admitted.
Okay, thank you.
Okay.
That's what we have on the, let me double check, please. Police drive-by suspect, that's not evidence. Another site, that's not evidence. Okay, Your Honor, that's all we have for that specific fireworks allegation in my pleading.
All right, fireworks we're done with, okay.
I would like to move on to
Wilner, before we go on too much, because I just don't want to get so out of order here, let me
Yes,
ask you a question on the fireworks incident. You drove up as this was occurring, is that correct?
Yeah, I would have to go back and look at my notes on this.
No, just, I don't want you refreshing your memory with something
Okay.
that's not the evidence. So did you actually, were these fireworks going off when you came to the house?
Yes, we were not in the front yard. We were, I believe, I was outside. I was in the alley. That's where I was.
Okay.
I was in the alley, and one of my dogs started barking at this, using a tone that usually says somebody is on the property. We have an intruder on the property. And so I entered into. I can turn one of the laptops around here so that you can see the layout of the property if you wish.
No,
But the front door and back doors face each other, and so I returned back into the back door. Saw the dog at the front door or at the window right here next to me, aggressively barking outside. I didn't see anybody initially other than our guests in the front yard, the children, the dad out playing with his 3 kids. And then we heard another round of the fireworks going off. And that then got my attention. And when I saw that, and this is the reason why I did not exit the building, is because I immediately called the police. That was the 911 call. Once the call had been made, the vehicle drove away, and I have all of this on video. But again, being mindful of the court's time, I wasn't planning on presenting another 6 video clips. William Chitwood got back in the vehicle, drove away for 5 minutes, and came back again. And so I initially thought that the threat had abated. He was back by the time the police had arrived. He had exited the vehicle in time for the first cruiser to pull up, which drove past him.
Can you slow down, please, sir?
Yeah.
Yes, ma'am. So when he had returned, he had exited the vehicle again in the same location. The first Manor Police Department cruiser approached and went past. The second cruiser did the same thing. A short while later, a matter of perhaps 2 minutes, 3 minutes, and no more fireworks were forthcoming. And so that was that for the time being. However, more fireworks were discharged later that night when it was dark. And I was straightforward and honest with the dispatcher. I did not claim to be able to accurately identify the perpetrator at that time, but it was in the same location, and the same truck was also visible at that time.
Okay, so these fireworks, were they just being randomly fired, or were they being fired at your house, or do you know?
These were being fired directly at 207. And
what is 207? Is that your address?
207 West Wheeler is the other property that I allege an ongoing criminal operation or enterprise between 106 and 207 as justification for as reason for shutting the property down. And I'm going to present very compelling video evidence of shots fired and drug deals ongoing and going bad.
All right, so let me stop. Stop.
Yes, ma'am.
We have got to move on. I just have a question for you. These fireworks are being fired at the neighbor's house, 207, is your testimony, not at your house. Is that correct?
These ones, yes. The ones that were fired at our house were not caught on camera. I do have a statement from another neighbor who is unable to be here today.
We would object to neighbors.
I respect that, and I would like to simply say this happens to be another retired airborne combat engineer. He gave a lengthy description of this, but I understand that without him being able to be sworn in or cross-examined, that we may not be able to introduce that as evidence in these hearings. But I will say that
that's an issue for you. So let's stop there, and I don't have any further questions. I was just trying to determine where those fireworks that you showed, they look to me like the Roman candle, sorry, Mr. Savage, Roman candle, was being fired. It looked to me like it was being fired across the street. And it sounds like that was what was happening. Is that right?
Yes,
Not
Your Honor.
It was being fired at 2:07. Is that right?
Yes, ma'am.
All right, please proceed.
What's our next one to prove?
Screen sharing.
So moving on to P120, I would like to enter into evidence or offer into evidence. This is an event where we first of all demonstrate that defendant Tracy Chitwood was on the property. There is a grouping of 4 videos that we would like to offer into evidence, which demonstrate Justin and Billy Chitwood both yelling extremely loudly to the point where guests checking in ask if it's safe to leave their car in the parking lot or if they could actually drive it onto the lawn and park it next to the stairs because of being frightened of Chitwood's behavior. So
so we can't let him in as a batch. We can't do that. You pick your best one,
let's
look at it, and then we'll see if we go for more. But let's start with your very best one.
P121, I would like to offer into evidence. In this video, the guests ask if they can park their vehicle on the lawn, and the Chitwood brothers, both Justin and Billy, can be heard yelling in the background.
Okay.
How you doing? Good. How you doing? Good. I'm your host. Oh, all right. Yeah. You have been seen? Yeah, it's good. Yeah. These things are good. They're good. You know, don't worry about it, man. I got the retired war dog. I'm out of shape now. Intelligent. Retired war dog. I'm picking myself up. When they talk to you, they do something like that. Yeah. You know what? They're fixing it. That place over there is for sale. Well, just would it be bad if we pulled up here? Are you worried about the car? No, I'm talking about the unload. Like, Your Honor, that's P121. P122 is the continuation, the rest of that conversation. I would like to offer that. I know I can't offer them both into evidence at the same time. I would like to offer that one.
Yeah.
As proof of guest consternation.
Okay, let's start with P121. Mr. Savage, any objection to P121?
I'm not sure what the relevance is. I might have missed something. I would object on relevance.
Well, I think that he's laying the foundation on relevance, so I'm going to overrule that objection. Mr. Chitwood, do you have any objection on P121?
Not as of yet.
All right, we're going to go ahead and admit P121. Let's hear P122. See how we do with that one.
Got 2 bags. Yeah, each. And like, That was just the wrong one. Sorry, did you mislabel this? Okay, pause this, please. Your Honor, we have, just bear with, can we beg your indulgence for just a moment?
Okay.
Is that the one that says I should have brought my strap? Guess has to park on the lawn. Your Honor, can we sorry, let me I still stay with, I offer P122 as evidence of the guest consternation, which is the foundation. And we also have P123, in which you will hear the guests referring to being upset that they didn't bring their strap, which is slang for a weapon, presumably for self-defense.
Well, I don't think we're going to be able to. I don't know what a strap is, and I don't know why they wish they had their strap or what that is. I don't think that is not good evidence. And I mean, it's just it's not going to help you. We're back on 122, which is what you just played.
Okay.
But you didn't quite finish it. So do you want to play a little bit more of 122 so that I can make a ruling on that? So.
We certainly can. We paused this because we made we had a clerical error on our end, and it doesn't include what we wanted to.
Okay.
Yeah, so we want to withdraw 122.
Okay, it's withdrawn. 122 is withdrawn. Okay.
And we want to offer as evidence. Yes, we want to offer into evidence P124, please, Your Honor.
All right, let's look at P124.
I apologize for causing that confusion.
No, that's okay. You're doing your best.
This, I believe, stands on its own.
Okay.
Your Honor, you can hear Billy Chitwood yelling from across the street in this video. Your Honor, I'd like to pause here.
Okay.
State as a witness myself that the two last comments that you heard were William Chitwood and Justin Chitwood. They were using the N-word not in relation to the black guest, but towards my person. And the comment, "Where you at? I see your fat ass," and replied to by Justin Chitwood saying, "Oh yeah, I see you over there." Those were comments that were directed at me.
Please proceed with it. Are you playing more of this for us? All right. What's this exhibit number?
This is exhibit P124. It's marked in the lower corner. Your Honor, I'd like to point out that the guests are running back upstairs after an interaction with the Chitwood brothers. And you have advised me, and I've withdrawn the previous exhibit, which was going to show them talking about getting their strap.
Okay, so let's talk for a minute here about this exhibit. You've asked to have it admitted to evidence, Mr. Savage. Do you have any?
No objection.
No objection. Okay. Mr. Chitwood, any objection? Mr. Chitwood?
So not right now, but I'll probably have some things to say about it later.
All right, you'll have your opportunity later. Okay, so it's admitted. 124 is admitted. All right, so.
I'd like to offer into evidence exhibit P123, please.
23, okay.
Oh wait, did we do this one?
I should have brought my gun, is what this one says.
Yes, ma'am. I paraphrased strap.
It's very, I mean, this audio is so hard for us to hear. I mean, it's really almost impossible. The only thing we can see are the pictures. The audio, I can hear somebody yelling, and that's about it. I don't know who's yelling. I can hear somebody yelling.
Okay.
If you want to try to put, I should have brought my strap on, and we'll object to it or not, and see if it's good evidence.
Okay.
I don't want to keep you from putting on your case.
It's fine, Your Honor.
Can't hear it.
We have such a preponderance of evidence that I'm fine restricting myself to the low hanging fruit. So I'm fine with leaving 123 and withdrawing my request to have that entered.
Okay,
I would like to say that 124, which what? Sorry, sweetie.
What are we looking at? This is March the 24th of 2022. So I'm looking on your list here to see where this is. I see, here it is. So is this Tracy Chitwood allowed Billy Chitwood to use the property to blare loud music? I didn't hear any loud music.
Yes, ma'am.
Let's see.
That's
Billy
coming.
Chitwood refrained from use property to shout at and to intimidate plaintiff and paying guests. That's what we just saw, right?
Yes, ma'am.
All right. Do you have anything else, any other exhibits on to shout at and intimidate paying guests?
Yes, I do. Let's do the truck burnout one, Laura. What's the number on that? That was renumbered. Your Honor, I'd like to submit into evidence P126.
And which date does this relate to?
This is the same date. This is the same set of guests. You'll see them coming out to their vehicle. You'll be able to hear more shouting. And then you'll see another burnout from the Chitwood brothers in the truck.
Okay.
And this all goes in support of Mr. Tate's evidence as well, that anytime anybody is visible outside, the Chitwood brothers would find a way to cause a commotion. In a moment here, you'll see the guests exit the vehicle and then run back upstairs, saying, "I wish I brought my strap," and I won't make any assertions as to what "I wish I brought my strap" means, but I'll just let the video speak for itself.
Be a little quiet so we can hear it.
Yes, again, very unfortunately, this camera was damaged,
Please.
Your Honor.
Please be quiet. Okay. All right. What exhibit number is this?
This is P126, Your Honor. I apologize for talking over it. Should I play it again?
No, I understand it. P126. And are you asking to have P126 admitted to evidence?
Yes, Your Honor.
All right, Mr. Savage, any objection?
No objection.
Mr. Chitwood, any objection?
No, ma'am.
All right, P126 is admitted into evidence. But I have some questions for you now, Mr. Wilner.
Yes, ma'am.
And I just keep breaking it up because otherwise it's going to take us forever to go all the way back to the beginning. Let's start with the other allegations on March. I guess it was on March 24th. Is that the one? Is that the shouting at your paying guest?
Shout at and intimidate plaintiff and his paying guests. Yes, ma'am.
Okay. Did you hear this shouting occur?
Yes, I was standing next to them in the previous
Okay.
clip, talking with them, and when they yelled out, "Look at that! Oh, I see that N-word with his fat ass," that was directed at me. Unfortunately, because the people were standing in front of that camera, you could not see them behind them because we were obscuring that view, which is why I added this extra clip from this camera to show this point of view to demonstrate that it was in fact the Chitwood brothers across the street who were making those comments.
Okay.
But I made
So,
direct eye contact with both of the brothers as they were yelling at us.
okay. So let me ask you, this was on the 24th of March of 2022. And in your testimony is that, what's this guy's name? That Justin Chitwood yelled fat ass at you and referred to your African American guest by a highly offensive racial slur. Is that what you're testifying today?
I cannot speak.
Are you testifying to that today or not?
Yes. Yes, I am, Your
Okay.
Honor.
All right. Now, what did you start to say? You cannot speak to what?
They continuously yell insults across the road at us whenever we're outside of our building. One of the most common ones that they use to refer to me with is fat ass.
Okay.
So my assumption was when Billy Chitwood yelled, "Oh, I see you, fat ass," that comment was directed at me. And when Justin added, "Oh yeah, I see you right there," that was also directed at me. Regardless of whether it was directed at me or at my guest, it's highly, highly offensive. The language is certainly inappropriate, and it's also makes no difference. The injunction is very clear about not even saying anything in a loud manner that would be considered offensive, much less that kind of language and insults yelled across the street.
So one of them sounds like William called you fat ass, and then Justin said, "There he is," right?
I believe that's correct, ma'am.
Okay. And then one of them used offensive racial slur at your African American guest. Is that right?
It was either at them or at me.
Okay. All right. So that happened, and that was on March the 24th of 2022.
Correct, ma'am.
Okay. Now, let me ask you about the truck burnout. I saw your guest getting into their vehicle, which looks to me like a black or navy blue Nissan, and then they left. You said we don't know why they left, but they left. But what I did notice is that the truck pulled into an area, and I just want to see if this is your property or not. There's a driveway here, and then behind it, there's some asphalt that's a slightly different color, slightly darker color. Is that your property there?
Yes. So this is also a guest vehicle. All of this is our property. This is the road here, and this is the Chitwood's driveway. So the truck backed up across the road, paused, backed further onto our property, and then did a burnout leaving that way, leaving
That's what I
northbound.
saw too. Okay, very good. Thank you. That's all questions I have for you on that topic. Please proceed as to the next issue.
Okay, so have I offered everything into evidence correctly? I'm just checking.
Yeah, I mean, I can't tell you, but I've got what you've put
Okay.
into evidence so far.
I would like to offer into evidence P120, which proves that Tracy Chitwood was present on the property at the time.
Okay.
Sorry, this is on a different date. This is on, I think this is on, oh, no. Yeah, it's the 24th.
Okay.
Yeah. So this proves that Tracy Chitwood. What's that? Yeah, so this video shows the two Chitwood brothers on one side of the vehicle and Tracy on the other side of the vehicle, examining and removing things from the truck.
Okay.
You can make her out here, and you can make the brothers out here. This is Tracy. So I'd like to offer P120 into evidence. I can also state for the record that I was a personal witness to this, and this was not the only time that Tracy was visible on the property that day with the two boys.
Okay. And that day was March the 24th of 2022?
Yes, ma'am. This is right about the same time as the incident that took place with the two African-American guests whose car is here.
Okay, so this is the same day as the truck burnout where the
Yes,
truck
Your Honor.
got onto your... Let's try not to talk at the same time. The same day as the truck burnout with the truck wheels got on your property, is that right?
Yes,
Is that
Your
a
Honor.
yes?
Yes,
Okay.
it is, Your Honor. And
Okay, and it's also the same day that someone from that house, either sounds like it was William Chitwood and or Justin Chitwood, yelled fat ass at you and N-word at your guest. Is that right?
Correct, ma'am.
Okay. All right. Is there any objection to plaintiff's 120?
I have a couple of questions about it that might bear on its admissibility, but I can either wait till cross or make an objection now on a conditional basis. But if I'm allowed to question the witness, it may address the issues for the court.
All right. Why don't you go on and see if we can't clear it up kind of on a order type proceeding, see if we can't get this cleared up now so I can admit it.
Thank you, Your Honor. Mr. Wilner, was this video taken at the same time as the video of the of P126 or P124 or P121? Basically, the preceding videos you just admitted.
Yes, excellent question, counsel. The timestamps are in the lower right corner of all of the videos. So to be really nitpicky, they're not at the same time because some of these are clips from the same camera, but you know, one after the other, and then a couple of the others were from different cameras. But the short answer is yes, these are all taken of the same incident over a period of perhaps five to 6 minutes, which you can confirm by examining the timestamps down in the bottom right.
And were you outside while this video was being taken and seeing what we are seeing on this camera?
Yes, I was.
Were you able to see Miss Curry personally during what we're viewing here in this video footage?
Yes, I was.
And how were you, where were you located?
I'll demonstrate here with the mouse. So you'll recall in a previous video where I was had my hands on my hips and I was talking with the two guests. That is immediately around this corner where the walkway goes. So that conversation took place about 8 or 9 feet in that direction. And I had a clear line of sight through here past the telephone pole to this whole property. So all of the events that unfolded, I'm a direct first-hand witness to. Certainly a witness to her presence as well, counsel.
Where is Miss Curry in this clip that we're looking at?
She's here, sir.
Okay. And that's her property, is that right?
Yes, this is 106 West Wheeler.
Okay.
And she is the deed and title holder.
Okay. I'm going to object. Basis is relevance. Witness here is describing my client as standing in front of her house at her property. And we are not seeing anything indicating a nuisance in this video that supports his case, so we would object on relevance.
Okay, the objection is overruled. Please proceed. Mr. Chitwood, do you have any objection to this exhibit?
No, Your Honor, I do not.
All right. exhibit, and this is 120, is that correct, Mr. Wilner?
Yes, Your Honor.
Okay, it is admitted. Please proceed.
Okay, Your Honor, that concludes our evidence for paragraph 9 in our pleading with regards
Okay.
to that incident.
Okay.
We'll move on to. Oh, yes, absolutely. I'm so sorry, Your Honor. My sweetheart has reminded me that I almost missed something. I would like to also offer as evidence P118. This is also on the 24th, and this shows loud music coming from the truck while it is situated at 106.
All right, let's take a look at it.
Oh, sorry. So yes, that is P118. I would like to state for the record that obviously if I had any control over any music of that sort being played on my property, which is a high-end furnished executive rental suites property, I would have immediately caused it to stop. That music is emitting from Billy Chitwood's truck across the road and is clearly audible in every room, in every suite in my building. And this is not a one-time event. This happened seriously, genuinely far too many times to count. We're not going to burden the court, although we certainly can. If there's any hint of disbelief in this, we have dozens of these clips available that we could play for several hours.
All right, let's go back to what you just played. So you're asking us to submit into evidence, and it's P118. Is that correct?
Correct, ma'am.
Okay. Any objection, Mr. Savage?
No objection.
All right, Mr. Chitwood. Any objection?
No, Your Honor.
Okay, it's admitted. Now, Mr. Wilner, I have a couple of questions for you. Which of these trucks belongs to the Chitwoods?
Neither one of these do. These are both client trucks. We saw this one in the previous video. You'll note that the date these are all still from the 24th.
I see them. Yeah, I see that.
This is a little earlier in the day. If you'll recall, the Chitwood's truck is parked over here, just slightly out of frame, and they're messing around with it and playing music. These gentlemen leave in their work truck, but you'll recall from the previous video that this black truck belonging to other guests is still there. in the other
Okay.
videos.
I remember it. So
this music,
Chitwood's truck is, just let me talk. Chitwood's
ma'am.
truck is a little bit out of the frame. It's a little bit to the right of the screen. Is that right?
Yes, Your Honor.
Okay, so let me ask you this. The audio in this, we could hear the music. I could not hear the content of it. I could hear music or some sort of loud electronic type noise. Did you personally hear this music?
Yes,
being
Your Honor.
played?
Yes.
Where were you at the time?
Directly below this camera is directly above the stairs going up to the second floor. We reside in the unit that is down and to the left.
Okay.
So I was exactly where I am right now, sitting in this chair, which is the second furthest room away in the building from the Chitwood's truck, and I could hear it where I'm sitting right now. And this
So
is
you could hear you could hear the music sitting inside in the room that's as far away from the Chitwoods as any other room.
Yes, Your Honor. We have
Okay.
other clips. They've purchased huge box speakers and installed them in their vehicles, as have some of their friends around here, and they rattle walls and doors. You can put your hand on doors and it vibrates things.
Did you confirm that this was the Chitwoods playing this music and it wasn't somebody else?
Yes, ma'am. It's a particular favorite of the Chitwoods. The lyric is with respect, F that B, F that B, F that B. There's another particular favorite of the Chitwoods and their friend Adrian, who resides at 207, which is just a refrain, F you, F you, F you. And whenever they see anybody engaging in any activity, whenever they would see any of our guests, it was very common for them to bring these highly offensive songs out and crank them full blast.
Okay, so these people who are sitting in your property, it looks like they're doing some work in a garden, it looks like?
They're installing a patio, Your Honor, and one of the clips
Okay.
that we're about to play very soon, one of them will come to the door and express his fear and consternation about the Chitwoods parading with an AR-15.
Your Honor,
Okay, and this, just a second. I get to ask a few questions too, okay? So this whole thing with the music, this was on the 24th again, but earlier in the day than the burnout and the
Yes, Your Honor.
shouting. Okay, all right. Mr. Savick, what would you like to say?
I apologize. I was not trying to interrupt. Zoom is challenging at times.
Barry.
But I realized I had one question that just may be much easier to ask right now than coming back. So if I may, Mr. Wilner, you agree that this video footage here in P118 is approximately 4 hours before the video footage that you showed of Ms. Curry in P120?
Can you check that for me, sweetheart? Thank you, Counselor. Just give us a moment to confirm that. I would not be surprised if that were the case, and I don't want to impede the court's time, but it is. This is at 3:20, and the others at 7:30. So it is about 4 hours. But this very much goes to my assertion that this music was a constant interruption and a problem.
No further questions on this.
All right. Very good. Okay, Mr. Wilner, please, are we finished with March 24th, or we still have more on March 24th?
We have one final one on March 24th. So I ask for P118 to be entered into evidence, please.
P what?
P118 that we just
I thought
saw.
we just admitted that.
Okay.
Didn't we? If not, I'll P118.
No objection.
Okay, Mr. Chitwood, any objections?
No, ma'am.
It's admitted. Okay, let's go on.
P119 is the last one
Okay.
that we will play today.
Okay.
No, not today, but for this date in question. I mean,
For March 24th, yeah.
Okay. So, Your Honor, that video clip clearly shows Tracy Chitwood coming down the ramp and joining her sons at the truck, which proves that she was on the property that day when the infractions against the injunction occurred. And you'll note that that timestamp is smack in the middle of the other video clips that we have presented as evidence today to the court. So I ask that I offer P119 as evidence.
Any objection, Mr. Savage?
Brief Wadier, exhibit. If I may, Mr. Wilner, the timestamp on this shows 1628. Is that right?
1628, yes.
So approximately 4:30 or so, 4:28 in the afternoon. Were you outside at this time?
Laura, can you pull up the timestamp on the other issue? I know the answer to this, but I just want to be sure. Pull up. Take a look at. Right. Yes, I was outside at this time, which is how I knew to go back in and check the recordings and save this piece of footage. If I had not been outside to see Ms. Chitwood come down the ramp, then I would not have known to go back in and check that footage and download the appropriate clip.
Okay. And so,
further to that point, I can confirm that I was out chatting with the workers.
okay. So it's your testimony you saw Ms. Curry walking in front of her house and immediately ran inside and hit record. Is that right?
I will object to the characterization of immediately, but I was fully aware that the injunction against Ms. Chitwood required her to have knowledge of the acts that were being committed on her property in violation of the injunction, and realized that this would be a very important piece of evidence for me to collect. Ring only stores evidence for 3 months, and so I made a point of immediately capturing this and saving it into this file.
No objection to the.
Yeah, we don't. Just to clarify for the court, Your Honor, you don't have to push record with ring buttons. They're motion activated. Anytime something moves, they automatically capture a pre-recorded length of audio and video.
Yeah, I'm familiar with how they work. Any objection, Mr. Savage?
None.
Mr. Chitwood, any objection?
No, ma'am.
All right, it's at P119 is admitted. Okay, so here we are, Mr. Wilner. Now, this is
Yes,
the
ma'am.
part of the day that I don't like to tell you, but you are coming to the end of your time. If for the 2-day announcement, you still have quite a bit to do, and you haven't called your wife yet. So
Okay.
you're going to have to figure out some way to speed this up a little bit. And I know I talked to you before lunch and said, remember, these videos bolster you. You don't bolster them, but you're still
Yes.
doing it. So we've gotten March 24th in, but good heavens, you've got how many more days to get us through here? Quite a few.
I'm going to jump, I guess, to the most compelling things. I would like to ask for the court's patience. I believe that there was a lot of needless delay this morning, making allegations of improper service that consumed a fair amount of my time. I don't know whether or
Let
not
me just tell you what, at the end of the 2 days, we are done. I don't have any more time in my schedule for you after that. So
Okay.
we've got a jury trial starting. We've got a lot going on. So you need to step it up a little. And I appreciate what you're trying to do. I don't have any good suggestions for you other than what I've already told you. Okay.
Yes. Laura, let's move on to the drug deal gone bad and the assault on our property. That will be okay. So I will, in giving testimony myself, I will say that we clearly do not have time to present the mountain of video evidence that shows a continuous pattern, ongoing day after day, month after month, for years. The effect on us has been extreme.
I know.
Draining.
I can only imagine.
So,
only imagine that music. You showed. Don't interrupt me.
Sorry.
I can only imagine. You just need to hit your main points here. Okay. So it's going to be hard for you to show me. I will tell you a quote drug deal gone bad without me seeing some drugs.
Okay.
But things like music, things like somebody, zooming their tires around and getting, calling you fat ass. That stuff I can see, and I that's something. But to say drug deal gone bad when it looks like somebody, I don't know how you're going to prove that up. Let me just tell you that. But if there's someone's getting assaulted or something along those lines, that's a different story. So take a minute, think about what you want to do. If we need to take a short break, we can.
Yes, Your Honor, I'm going to further truncate my presentation of evidence, and while I'm preparing, I am going to ask Laura to play I'm going to offer into evidence P140, which is footage of one of our workers coming to express his concern over William Chitwood and one of Justin's compatriots, an Adrian Estrada, parading with an AR-15. We will not submit multiple videos with that AR-15 because we've already addressed it with Chris Tate. But this is very profound evidence, and while that's happening, I will.
Okay, let's take a look at the AR. So what number is this, Mr. Wilner?
This is
P140.
P140.
Okay, and it looks like this is from the 26th of March of 2022. Is that right?
Yes, ma'am.
All right, let's take a look here. So are these the workers at your property putting in the patio?
Yes, Your Honor.
Okay.
Yes, sir.
Yeah, word of word, we just saw one of the jackasses, the guy in the black shorts, who got that truck where he died, red pants, with an AR-15.
Oh, really?
Yeah. The guy in the black shorts there, just get out with an AR-15. Word of one.
Okay.
Talk to you better now.
Oh, there it is right there.
Actually, I would like you to know.
Yeah.
You know about that wasp nest up there? It looks inactive, but
I've sprayed it already a couple times. No, it's fine. You can tell him that. I'm going to ask you about that, sweetie. I'd like to enter into offered evidence P141. Oh, sorry, P140.
Okay. Mr. Savage, any objection?
I would object. It contains a conversation with an individual. I don't know who that is. don't know what he saw. I don't know anything to understand, nor am I presented with the opportunity to cross-examine that individual about those questions. So I would object on hearsay and on relevance.
All right. How do you respond, Mr. Wilner?
I'm the one who originally set this trial down for 2 days. It did not occur to me that I would need 3 or 4 days to do this. We have what I would describe as a sufficiency of video clips showing.
I'm going to overrule the objection. Any objection, Mr. Chitwood?
I would object on the relevance of the fact that neither me nor my mother are involved in this.
Okay.
We're not
the objection-
cited, we're not seen,
Yeah.
we're not heard of.
Okay.
Also, a piece of awareness for the court, William is not my brother, he is my uncle.
All right. Well, I'm going to overrule those objections. Go ahead, Mr. Wilner. But thank you for that, Mr. Chitwood. That's helpful to know. Please go ahead, Mr. Wilner.
All right.
It's admitted. It's admitted.
Okay, it's admitted. Next, Laura, please play what's the clip of them wanting to quote unquote dance in pussy.
So let me ask you a question about this, Mr. Wilner. This March 26th, did you see this AR-15 rifle out there referenced by your guest?
Yes, I did. The Ring doorbell camera is only about a little over waist height, so it's lower than the top edge of the fence in that video. I'm 6'1". I had no trouble looking over and looking at it directly, and it was clearly visible. It was carried into the house and then brought back out again and displayed by the truck before then being carried back into the house again. So it was a very overt effort to parade the thing. My wife is also going to testify as to the number of times that they paraded the AR-15 back and forth in front of our property on Wheeler Street while yelling threats at us.
Okay, let me ask you about that. So when they brought out the AR-15 on this occasion, which was March 26th of 2022, were they also yelling threats, or did they just have the AR-15 outside? What were they doing with it?
They also yelled threats. In particular, one of the ones that really stuck in my mind was that it was better than, quote, my pussy shotgun, end quote. And there were plenty of them, again, apologies for language, P-word shotgun. And this was a refrain that was issued several times, that it's way more effective, better range, kill more people, etc.
So who said this to you about your shotgun? Who said this to you?
Most of these comments were made by William Chitwood, and I cannot say for certain whether which ones were or were not echoed by Justin, and I'm not going to try to embellish anything. There have been so many incidents, I can't honestly.
All right. It's admitted. Those are all the questions I have for you on this incident. How else? What's your next one you want to talk about?
The next one is an incident that took place on March 29th. We were unloading groceries. Go ahead and start it, sweetheart.
Okay.
And sorry, I keep calling them the brothers, the uncle, Justin and his uncle were at the property and yelled out comments about wanting to dance in my wife's P-word. There's nothing else really that's heard on this, Your Honor.
Okay. All right. So what exhibit number is this?
This is P205.
Okay. Any objection, Mr. Savage?
No objection.
Okay. Any objection, Mr. Chitwood?
No, ma'am.
All right. This admitted. All right, Mr. Wilner, were you present when these comments were made?
Yes. I was in front of Laura at the time, my wife.
Okay. And you all were unloading groceries? Is that what you said?
You can play the whole clip if you want to see us coming and going to the car with groceries, but
no, I don't need all of that. Okay. Like I said, this is your testimony. So you were unloading groceries, And then who started making these profane comments at your wife?
It was the uncle, William Chitwood, and also Justin Chitwood. The louder one, the one who screams the louder in most of these clips is William Chitwood.
Okay.
Justin is usually present and has his own comments to add to it but he doesn't scream as loud as his uncle.
Okay. All right. Very good. You may proceed with your next incident.
We are now going to start with the drug deal, and I look forward to providing sufficient proof that this was a drug deal gone bad by the standard of a standard of which any reasonable person would drive at. Sweetheart, can you just pull that up? I can't find the list, so we're going to take it directly out of the folder, and I'll announce it from there to save time.
And the last one, the profane comments about your wife, that was the March 29th, 2022 incident. Is that right?
Yes, ma'am.
Okay.
I have to say personally,
yeah, I know it's ugly. I know. Just save it. I heard it. I heard it. Okay. Catch your breath. Take a minute. Okay. You're doing a great job. Just try to stay in the cool place. It's very hard to represent yourself, and this is why it's hard. I know it's what you got, and you're doing a good job. Pat yourself on the back. Take a deep breath, settle down, and stay focused. I heard it. I know what you're talking about. All right.
It's my contention that there was an ongoing effort to incite me to violence, which would have deprived me of my family and my home and my livelihood. And I'm thankful that I was able to avoid that incitement. I would like to submit, what is this one?
This looks like P019 is what it looks like.
Yes, ma'am. Let's go ahead and watch this.
Okay.
Your Honor, before this plays, I would like to inform the court that I've equipped this building with what's referred to as a combination low light and infrared beacon. So it will cause certain fabrics to fluoresce in the darkness, which makes it easier for a standard or a commercial grade or consumer grade camera to identify movement in the dark. We're going to see an individual who will very shortly appear topless and covered in gang tattoos pounding on our front door at 20 to midnight. He's approaching from the south. He's going to check the Chitwood's mailbox and then enter the Chitwood property for some time. Here we go.
All right. I see he's checking the mailbox.
Yes, ma'am. He doesn't bother with hours. And again, I have footage of people checking that mailbox many times that I've sat up all night reviewing footage, but we don't have time for it today. He's now going to check that derelict black Honda station wagon.
Okay.
He'll move about the property a little more, and then he will leave the Chitwood's property and head in the direction towards 207. Okay, in the interest of time and anticipating the very reasonable clarification of the chain of events here for opposing counsel, I would like to draw your attention to the timestamp on the
Right.
bottom right and note the number of minutes. This individual is at that property for a period of time. There is
Right.
going to be a 2-minute gap between this video and the. Oh, sorry. May I? I'd like to offer this as evidence, as one of several videos that, taken together, provide very compelling evidence of a drug deal gone bad. B108.
I'm seeing this is 10019.
Oh, my apologies. Yeah, it's 019.
All right. So, are you moving to have that admitted, Mr. Wilner?
Yes, I'm offering to have that admitted.
Okay. All right. Any objection, Mr. Savage?
I'm going to object. I understand he says he's going to link it up with some other videos. So if those don't come together, I'm not sure what the relevance or foundation is for this video in the context.
I tend to agree with you. Let's hold off a little bit on this one and see where it goes, because I'm not seeing the relevance, and I've told you about this one. I really totally with you see the relevance on the the AR-15 and calling you ugly names and saying ugly things to your wife and calling people N-word. I see relevance on that. Okay. Some of these things are just, they're hard. The AR-15 to some degree, this stuff looks a little harder to prove.
I apologize for that. So I would also, there is going to be a chain of 4 or 5 videos which display this chain of events, and they overlap, and they will create an unimpeachable, impartial display. And I'll leave you to make your own, obviously your own judgments, but it's indisputable. What we're about to see in this is an individual pursued, and you can just make them out right now here. But one of them is going to run onto our property, straight to my door, which is here on to the left of the stairs on the ground floor. Another one is going to pursue him onto the property, and a third one is going to run past these lights to 207 to retrieve a weapon, where they will come back and assault the first individual before running out of here. They will be referenced to Adrian Estrada by name, and in the end, this shirtless person covered with gang tattoos who yells, "See what happens when you steal my S-word," many times. They will, after having run him off, retreat back onto the property at 106 with a bag dropped by the first individual. And then we will see police arrive, we'll see a canine unit, and we will see an an APD chopper engaging in a manhunt to recover this individual. This is taken all together is very compelling. All right, pause this and let's offer him to play the sequence.
Now that's looking relevant to me. I don't know. What was the number we just looked at?
That was P021, I believe.
Okay.
And this is P022.
Okay, we'll take. What are we looking at now?
This picks up where the other one left off. It's a little overlap, but this is gonna show. You heard him banging on my door. This is gonna show him banging on my door.
Y'all steal my shit, watch. Oh, jumping asshole. Y'all hoes, nigga.
is that?
That's Adrian Estrada.
Okay.
He's going to appear in other videos as well, equally not quite as dramatic as this, but very compelling. He's been previously trespassed from our property. He's clearly identified in multiple camera angles on this evening and referred to by name. All of this information was provided to Manor Police Department. They declined to press charges and also
But
declined.
what does he have to do with the chit? With what are their names?
The ongoing criminal conspiracy is that and I will not say this as a statement of fact, but any reasonable person with any amount of knowledge or firsthand experience in matters involving security and operations, etc., as I have decades of. Within the first day of buying this building, I identified an ongoing enterprise between 106, which is Tracy Chipwood's property, and 207, which is just almost across the street on Wheeler Street. 106 appears to be the stash house where material of some type is kept and then regularly ferried for distribution to 207. The common assumption for this is that there will never be enough material stored at the site of distribution for the property to be seized via RICO. And this is a standard operational tactic that's been in place for pretty much since the mid-'80s, but has certainly gained much more, become much more commonplace in recent decades. I don't have the warrants. I don't have the active clearances anymore to engage in an official investigation, but I can state with some clarity that that is what this has every appearance of being. I won't state it as a matter of fact, but I will leave that observation to the judgment of the court.
All right, so you're trying to get admitted, and then we really do need to. If you're going to have your wife on, we need to get her on, okay?
Yes.
So what you're trying to have admitted is P109, P019, P021, and P022. Is that correct?
Yes, that is.
Okay.
We're not. There are several more to round out the conclusion or this sequence. If we could present them all together.
This strikes me as a pretty big piece to try to bite off here. Mr. Savage, how do you respond?
I haven't heard any evidence that indicates these individuals are connected to Miss Curry's property, except that one of them walked by her property just like they walked onto property. So we would object on the basis of relevance.
I would like to respond to that. If you'll just indulge me, I will play you one more clip. You will see them run off of my property, pursue this guy, and then they will retreat into Miss Chipwood's property.
All right, we'll take a look.
Go ahead. So in that, you can clearly see Adrian's identified by name and by voice. They pursue the suspect or one of the individuals this way, and then they retreat back up here and onto the property. The video that I did not provide as evidence to the court included a detailed description of the placement of a bag in the back of this Dodge Durango here. But I believe that this shows conclusively that this chain of events both began with an individual walking up this way, and within 3 minutes it had spilled over here onto my property, a shirtless individual covered in gang tattoos, yelling about having, we'll see what happens if you steal my ass. An assault was committed on the property with a bat, which incidentally cost us a Whole Foods contract. I can explain that, and we have video of that as well. And then it again spilled out over this way and ended up back on Tracy Chipwood's property. I believe that's shown conclusively with these 4 videos.
Okay, so you're seeking to have admitted P109, P019, P021, P022, and P026.
Yes, Your Honor.
Mr. Savage, how do you respond?
We maintain our objections, and I'm looking at the petition and what his allegations are with respect to this state concerning a drug deal. This has no video footage of any drugs or any other useful evidence that helps sort of illustrate, I think, what that allegation pertains to. I also point out it doesn't allege that the person's going back to the house. This is new information. I maintain the objections on relevance to my foundation.
Okay. Mr. Chitwood, how do you respond?
I agree with Mr. Savage.
Okay. I have to think on that one a little bit. Let's go on and take our afternoon break here. It's 3:15. I keep looking at the clock on this from these videos, but it's 3:15. We'll return at 3:30, and I'll make a ruling on those, okay? All right, we're taking a 15-minute break.
The next part's coming. Don't worry. I won't leave you hanging. It's coming just in one moment. We get to see Sweetie Poo in the flesh. Oh dear. Okay. Bring that one for here. Put this thing into full screen. Unmute it.
Also, I do not remember exactly which allegation we left off on. I believe that it was March 28.14, either 14 or 15. May I beg the court's indulgence and have the court reporter just let us know so that I don't go over the same ground twice or omit anything?
Ms. Gonzalez, can you tell which date was the last date discussed in the record?
I can read back the last question.
Okay, why don't you do that? Maybe that'll spark his memory.
Question. Okay, and so in the interest of time, And and I do hope that we will be able to have maybe another half an hour in the morning to wrap up. But can we move on so if I can summarize what you just said, Ms. Wilner, and then the court. No, you cannot. No, you cannot.
Okay, does that help you, Mr. Wilner?
It doesn't. So let's pick up again on paragraph 14 on or about March 28th. Sorry, Ms.
This is not the next one. Just give me a moment. I apologize. What I will do instead is this. For 1 minute while I find this video. These people were in this court for so long. Oh my god, I wanted to kill them. I mean, I did not at all. Okay. I have to think about this properly. Because it was the same day they came back, so it was the 21st. So it was just one more moment. There it is. Okay. Maybe not. Maybe I still have to find it. I apologize that it's taking so long. It is my fault because, I didn't. No, you didn't lose me. I'm here. I'm just trying to find video for you because I don't want to leave you with a wrong impression that we skipped the day. Ugh. I don't sound Canadian? Really? I am very Canadian. Here's a funny story I'll tell you. I used to work for a place called, it was for AT&T, and we did customer service for AT&T, like business customers, and they did not want us to say we were Canadian. In fact, in training, we were specifically forbidden from saying that we were Canadian, and they trained us on what to say. So if people asked you where you were from, you would just say, "Oh, just north of Seattle," because that's where we're from, Canada, just north of Seattle. But I did have people often say that I sound like I'm from Minnesota. But that's one. Yeah, that was a fun job for a little while, about a day, to be honest with you. And then I didn't like it anymore. So yeah, let's do a little recap in the middle here while I'm finding this clip. I know what we can do. I know what we can do. We can. No, we can't really. What I was gonna say was, he wants to get he wants to kick his neighbors out of their house and make them stop being there. I know video's stuck now because maybe we did just go to the next day. Sorry, phone's fucking going off the hook right now. Oh my goodness, who's texting? Anyways, jeez. Is this the same day? No, it's not. It's 20 seconds. I keep telling myself that it's not the same, but anyways. This is how you ruin a live stream, and this is how you kill momentum. But I give my people lots of points that mean nothing to anybody but us. He is a fat ass. I bet he was. I don't mind fat ass talk. Yeah. What the problem is, you know what, we're just gonna have to watch this part, and then I'm fine the next part. I can.
Wilner, do you recall which
So,
one of these?
before you get started, William, because I'm really just honestly done with you, to be honest, but here we go. What I'm gonna do, William, is give everybody in here 1,000 points that's in the room right now. So that'll take me a couple minutes to execute. But I'm not leaving you hanging. This is gonna happen. I'm literally like concerned that there's a clip that I'm missing. If you notice, this is 2 hours and 42 minutes long. The next part of it, and then there's a third part that's like the verdict is only like 10 minutes with the closing statements. So I think that this part, thank you, Jonathan, that's hilarious and actually totally worked. This is what we'll be showing now. Laura here is Sweetie Poo. And I'll turn the game down or whatever. I back off of it too, probably. Okay. Let's hit play here and get it going.
These points we left off on yesterday.
Judge, I can go back one more question.
Yeah, let's go back one more question and see if that helps this gentleman.
Question. Ms. Wilner, can I also, further to that point, there was a period of time where you refused to go out the front door to walk the girls, as we refer to our dogs, for a period of days, and instead restricted yourself to taking them out into our backyard. Can you describe what led to you taking that decision?
All right. So,
see how we missed something?
Thank you so much. Oh, sorry, Your Honor.
Obviously, I have to. This is just because this is the way I am. I'm looking for it. You have to give me a minute because that gives me. Okay, here, found it. Oh my god! It's another 4 hours. Okay, hold on. I've got the right video. I will send it to myself and properly put it on now. Just 1 sec. That's hilarious. Is it on my history? What is my grandma watching? You just heard it say, my real problem is that he's cheating on his girlfriend. Like, what is Nana watching? Jesus, and I thought I was full of drama. Also, I don't have the chat right now. So just bear with me 1 more second. I swear to God, this is it. Now. No, what it was is this same day, there's another 2 hours of this just testimony.
Here,
And
where
there
we left
is
off was with Mr. Wilner had offered P 019, 021, 022, and 026. Mr. Savage and Mr. Chitwood had objected based on relevance. I have looked at the evidence and over the break and thought about it some. I think it's minimally relevant. And I know, Mr. Wilner, it's highly relevant to you, and maybe you can still close the loop on it. The other things that you have presented, I thought, were a lot more direct and had a lot more weight in this process. So I'm going to admit it, but please keep in mind that I'm weighing this evidence, and honestly, it's a darn close call, because we see somebody in the dark walking over by the Chitwood place. We can't really tell what they're doing. I hear what you're saying. You've had some experiences in this life which really have led you to believe strongly, and I'm not doubting you that there's, just based on your experience, this appears to be a drug thing going. We just don't see that. What we've seen, and you put on some good evidence of, is loud, obscene music, ugly name calling, weapons being present, and some fireworks, although that was a little less helpful. But okay, you need to wrap up your case, though, sir. So what do you want to do?
Okay, Your Honor, a quick question on that. How much time do I have left?
Well, we have you all have announced for 2 days, and so, which means that Mr. Savage can take all day tomorrow. It's 3:30 in the afternoon, and we do go until really till 4:45, so my staff can get out of here, right? Because we get trapped in downtown traffic. So that's kind of where you are. So you need to figure out how you're going to best spend the remainder of this day, which is not that much longer. It's a little under 90 minutes. So how do you want to do it? And I ask you that because I don't want you to feel surprised when I say, time's up. Mr. Savage gets his time now. Okay?
All right. I would like to play 2 clips that are that can be taken together with the evidence previously offered of the ongoing drug conspiracy. They are of a shot being fired and of a police officer walking onto my property and asking if they can collect a bullet from my building. And after that, I will leave it to Your Honor because we don't have any more time, and I'd like to get my wife sworn in and have her speak.
Yeah, I would like to hear from her too. I mean, truly, as I keep telling you, the testimony is
Okay.
powerful here. So let's go on and get your video clip on of the police officer.
Okay, just find the police officer walking in and asking to get the bullet from the building. We're going to skip all of those, identifying the security vehicle, the chase car, the foot scout, all of that. Just skip all that. Yeah, that's the one. So, Your Honor, I would like to offer into evidence. We don't have time for context, so we just have to play it. And I want to play the video that actually shows the shot as well.
I'm sorry, yeah, I'm sorry, I'm Officer Dave. Where's Dave, right? I'm going to require, obviously, documentation of your entry into the property in the event. Okay, yeah.
We're not seeing anything. We're hearing just an audio. So you wanting us to see video or just hear an audio?
No, it should be video as well.
Okay.
And sorry, Laura, this is the wrong order. But go ahead and play this because we're pressed for time. Just skip everything except the one with the gunshot. Yep.
Still not seeing anything, so let me know when you want me to be seeing something.
Yeah, you should be seeing something. Laura, I don't know what's happened here.
Mr. Wilner, can you hear me?
Yes.
What you will need to do is Miss Wilner will need to make sure that she's sharing the correct screen. If she's got multiple screens open on her device on her laptop, she might be sharing the wrong screen.
Thank you, Ms. Guardiola.
I still don't see it being shared. It's not sharing. I don't know why.
I don't know. It's the exact same thing. Doesn't show. It's showing in my feed.
Ms. Wilner, what I can see on my end is a blank screen that says Laura Wilner has started screen sharing. That's what I can see. So I don't see anything other than that right now.
Just close this, Laura, and then just close the window entirely and log back in. So there's that. There we go. Okay, just close the application and relaunch and rejoin the meeting. See, you're only viewing the window there. Are you sharing the screen? Okay, try it now. No, it's only sharing the window. I'm going to try to share my screen. What am I picking? Yes? No. Yes. Okay, I'm sharing on my screen now. Is this showing up?
Okay. Yeah, I can see as you had before a bunch of your video clips.
Which number is it?
Oh, gotta go down a lot.
How far am I? Okay, which is the one with the shooting? Shots fired. Here we go. Is it not showing again?
I'm not seeing it. I see all of your video clips, but I'm seeing ambulance, door, police arrive at scene, door, they shot that. I can't see the rest of it. So what I'm seeing here is it looked like it was P080. It might have been the one you wanted to line up, but I don't know for sure.
Okay, it's showing.
All right.
All right. So I'll preface this by saying that I did take the time over several days to put together this entire transaction with all the video. Instead, we're just going to look at the moment where there's a gunshot. Turn it up.
Now, is that a police car we see across the street? No.
Your Honor, I believe Mr. Wilner may be muted.
I can't hear you, Mr. Are you trying to say something, Mr. Wilner?
Yes, thank you, Counselor. I said that I did not have the time today to present all of the other videos and reconstruction of that incident that I offered to MPD, but I would like to offer that P076 as evidence in conjunction with P083.
Can you repeat that number?
P083.
And the first one was P076?
Yes, Your Honor.
Is that the one we just looked at?
Yes, Your Honor.
Okay. All right. And we have not looked at P083 yet, right? Are you going to play that one and then we'll try to get them in together? Is that the plan? Or?
Yes, Your Honor. This is the one that we weren't able to play on Laura's computer.
Okay, let's look at this one. Is that a Maynard police officer?
Yes, Your Honor.
Maynard police, okay.
This is Officer Vega.
Okay.
And then it carries on in another video where he confirms that they would like to come back and retrieve evidence from the building, etc.
Okay, so let me ask you, the very first video that you put on, I guess it's P076, that looked like they were in front of the other house that you've had concerns about in the area. Is that where the shot was fired from?
Yes, Your Honor, and I only offered these two videos in support of the other ones about the ongoing drug interaction taking place at these two properties. That's the sort of the two of them are foundational, and as per your instruction, I don't want to spend a lot of time on that, but I believe they support the earlier videos.
Okay, very good. Mr. Savage?
No objection.
Mr. Chitwood?
I would just like to object on the relevance, to be
Okay.
honest.
All right.
This has nothing to do with me or my mother.
Yeah, I'm going to sustain the objection. All right, so let's proceed. Mr. Wilner, you going to put your wife on so we can hear from her?
Yes, I'm just closing this,
Okay.
and I want to make sure that we don't have wait a second, stop sharing. I don't know where this is supposed to be, right here. Stop share, there we go. Okay, so yes, we'll probably have to have her go into the other room so that we don't get the feedback on.
Yeah, I understand.
So yes, I would like to have her sworn in now, please.
Would we be permitted an opportunity to cross-examine Mr. Wilner?
Oh, that's right. Sorry. Of course, he has been testifying.
I should add, Your Honor, I don't expect tomorrow to have very much. I don't think it'll be long when we present our case. So.
Okay, because I am getting very concerned about time. All right. So, Mr. Wilner, Mr. Savage makes a great point, which is you have been testifying, and so he should have an opportunity to cross-examine you. I got a little bit ahead of myself wanting to hear from your wife and try to get things wrapped up today, but it seems like we might be able to still keep your case on a little bit longer in the morning if we don't get this wrapped up. So with that, Mr. Savage, if you would please, with your questioning, and then we'll allow Mr. Justin Chitwood to ask some questions, although when he does, he is going to need to come on camera. I've been patient with that, but he will need to come on when he questions. So, Mr. Savage, your witness, you may proceed.
Thank you. Mr. Wilner, I'm going to go through your petition. I want to try to hammer down some facts and the points that you've alleged against my client, Ms. Curry. Starting on page 4 of your motion, specifically paragraph 15.1, recall making an allegation that Ms. Chitwood failed to instruct Justin Chitwood and any other person on the property to refrain from committing any acts that reasonably are calculated to cause discomfort or annoyance to persons of ordinary sensibilities attempting to use and enjoy your property.
Yes, I'm reading it here.
Okay. But understandably, you're not privy to every conversation that Ms. Curry has had with Mr. Chitwood or other individuals that she may have associated with at her homestead. Is that right?
No, I've not been granted a warrant to place a listening device inside of a residence.
Okay. Well, that brings up a good question. At some point here, would you agree that you are very much focused on trying to scrutinize the conduct of Ms. Curry at her home?
I believe that the intent and the language that was used in that injunction is very clear and with respect, and I don't mean to impugn you in any way. I think that this is wordplay. The intent of the injunction was for Ms. Chitwood to prevent anyone from engaging in these, presumably by instructing them not to do so, and that the fact that these incidents took place is evidence that she failed to issue those instructions.
Do you agree that the property that you're presenting evidence on today is Ms. Chitwood's homestead, Ms. Curry's homestead?
I'm sorry, we had a feedback loop there. Would you please turn down your speakers, sir? Can you turn your speakers down a little bit, sir?
I'm not certain it's mine. I'm running
Okay.
everything on one computer.
Judge, it kind of looks like it might be yours getting feedback for some reason.
So what should I do? Try to turn it down? I'll tell you what, I'll turn it off. Okay, I'm gonna turn it off.
Okay, sorry, Counselor, could you repeat your last question?
Do you agree that the focus here of your case is conduct that Ms. Curry is engaging in on her homestead?
To be clear, the matter at issue here is the conduct engaged by anybody and Ms. Curry's properties, not just Ms. Curry. Chitwood.
All right, I'm looking at your petition with respect to the allegations that happened on January 1st, 2022 concerning fireworks. It's your testimony today that you personally saw Ms. Curry, personally saw Ms. Curry allow Justin Chitwood and Billy Chitwood to shoot fireworks from Ms. Curry's property?
No, with respect, Counselor, that is wholly and entirely inaccurate. I was very clear that I did not see the fireworks which were fired from the property. I made reference to a third party, an ex-ranger, who did and who had provided a statement. I acknowledged the fact that that was not admissible in court because he could not be questioned, but I did witness him moving his vehicle down the road and recommencing, not moving his vehicle down the road, but I did witness him after moving his vehicle down the road, commence firing fireworks at other properties. And it was very clear about that.
Okay, I'm trying to read your allegations and understand the evidence that you're bringing.
I think the evidence that I brought is very clear, and I've already acknowledged any limitations that that evidence may have.
So, who is the party that you're saying supports your allegation that Tracy Curry Chitwood allowed Justin and Billy Chitwood to shoot fireworks?
In the interests of brevity at the request of the court, I'm just going to respond with asked and answered, sir.
Okay. I'm going to go up to your paragraph alleging certain misconduct on February 15th, 2022. And I see that you've alleged that Ms. Curry, do you agree that you've alleged Ms. Curry allowed individuals to use her property to continuously pace back and forth while staring at your property and make comments in an intimidating manner? Do you agree with that?
Absolutely.
Okay. Now, who specifically are you alleging saw Miss Curry allow individuals to do this misconduct that you've alleged?
Again, sir, asked and answered. The fact that these actions took place on Ms. Curry's property when she was enjoined from allowing them to take place on her property is evidence of her failure to abide by the injunction.
Is it your position you don't want to answer what witness saw the misconduct you're alleging?
Okay, no, that's not my position. But that was not your question. Your question was, your question related to whether or not I saw Tracy Curry Chitwood enjoin someone from committing these actions. Or did I mishear that? Would you care to perhaps restate your question or rephrase it for me?
I'm reading your allegations and I'm asking, who are you alleging saw Miss Curry allow these individuals to do this misconduct outlined in paragraph 4?
We have to pull those videos up and take a look.
No. I'm not asking to pull any videos up.
Yeah, okay, hang on a second. Maybe I can make this a little easier. Mr. Savage, I think these things you're questioning him on are outside the scope of the direct examination of his testimony.
Your Honor, I'm reading his petition and asking.
I get it. I
should be able to ask.
But it's outside the scope of direct. You're bringing in new facts at this point. What's your point here, Mr. Savage?
Your Honor, I'm reading his petition and determining what evidence he is presenting to understand what we would need to respond to. And I'm not limited to the direct examination. Respectfully,
we have just respectfully, right? Respectfully, he's talked about March 23rd. He's talked about March 24th. He's talked about March 25th, March 26th, March 27th. March 28th, March 29th. I didn't see any others. Now, maybe I missed something, but you're now talking about dates that he didn't bring up. So I'm kind of confused here. There's no evidence on of this. He hasn't put evidence on of this. So what's your point?
Well, he did ask about January 1st. He presented evidence. I've asked some questions about that. He presented February 14th, and I certainly may ask about that, but I've skipped that for now. And I went to February 15th, which was evidently right around the same general time frame as that February 14th time frame.
In my view, if you're talking about things that he talked about, then you're good. But in my view, if you're talking about things that he didn't even talk about, that he didn't bring up, then what are we doing? What are you doing? I mean, let's just put all aside whether or not you can, question outside the scope of direct. I mean, I don't think you can, but just from a practical perspective, what are you doing? Stay focused on what he talked about, and then we'll get through this, okay? But asking about things that he didn't talk about, we're going to be here for another 2 days. So those are my views. I'm not, if you still want to persist in it, you can. But I'm just telling you, that's kind of how it sounds to me right now. I'd stay on stuff that he's talked about. Ask him questions. He gave you plenty of good stuff to talk about.
Absolutely. And I'm working on that. Thank you, Your Honor, for working with us to narrow the issues. I appreciate it. With respect to Mr. Wilner, paragraph 8, I want to focus in on this allegation that Miss Curry allowed Billy Chitwood to use the property to blare loud music. Can you clarify specifically any witnesses who you may have presented or understand to have knowledge of Miss Curry allowing such misconduct that you've alleged?
Again, I've asked and answered this already. I do not have access to the inside of her home and all of her conversations. But again, the fact that the incidents took place while she was on the property with her knowledge and loud enough to be heard inside my building with 7 walls separating me from it through these windows right here is sufficient that she was aware of these things happening on her property and either presumably made no effort to stop them or was unable to stop them, in which case she should have called the police herself and taken the appropriate measures in order to not violate the injunction.
Would you
And
agree?
I did present, again, not to split hairs, but I would like, and since the judge has asked for brevity here and to keep things concise, this is the reason why I did not present the video evidence for February 15th, is because I wanted to follow the judge's instructions. I've also said in 4 different ways now that I do not have access to the inside of Ms. Chitwood's home, and I'm not privy to all of her conversations. So I would ask respectfully that you stop asking me the same question.
Do you agree that the people that you are having problems with are with Mr. Mr. Chitwood and Billy Chitwood, Justin Chitwood and Billy Chitwood? Do you agree with that? That those are the
No, I do not agree with that.
Who are you having problems with then?
I have problems with the owner of the property who's been enjoined from allowing it to be abused or used as a public nuisance, and who's been enjoined from allowing certain activities to take place on that property, and who has violated the injunction by allowing them to do so. I certainly have a problem with anyone who behaves inappropriately, who makes threats about wanting to dance my wife's P word, et cetera, and the other things that we've heard. But your attempt to shift blame off of your client onto her relatives is both noted and dismissed by me. It's my opinion. I mean, to say I have a problem with everyone who's behaving inappropriately, but I'm not.
Let's not be argumentative with him. I get it. You've answered it. I think that but we don't need to argue with him. Mr. Savage, please.
Okay.
Okay, regarding March 23rd, 2022, I just want to make sure I'm unclear. You did not see Ms. Curry undertaking a specific action regarding the blaring of loud music or directing music in a way that was reasonably offensive or anything of that sort. Is that correct?
No, that's incorrect. She was at the property and allowed the music to emanate from the property.